before we begin any procedural matters to address? All right, then we will resume with questions from commissioners for this panel.
Chair Mitchell, actually, we had just a couple of remaining.
All right, Mr. Mehta, you may finish out.
And I really mean just a few, less than 5.
Okay.
Ms. Abernathy, let me start with you. When we left off last night, you had indicated that test year bad debt expense should be or would have to be increased by approximately $42 million in the event that the continued deferral of COVID bad debt costs is denied by the commission. Is that right? Just to level set us?
Yes, that's correct.
So the impact on customers will be less if this issue about the continued deferral is resolved in the company's favor.
Yes, that's correct.
And if the commission were to disallow, as advocated by public staff, cost recovery of the existing bad debt in the deferred costs, that too would lead to an increase in test year bad debt expense, because test year bad debt expense is net of the deferral, the costs in the deferral account, correct?
Yes, that's correct. We'd have to make a similar adjustment to the adjusted test year for bad debt expense.
And would the similar adjustment, again, similarly result in the same $42 million increase in revised test year bad debt expense?
Yes, we need to adjust by approximately 42 million to represent current levels of bad debt expense.
Ms. Bowman, let me turn to you. And you've probably, in light of all the questions you received yesterday and your review of the public staff's position, not only in this docket, but in the deferral docket, would complete disallowance of COVID costs as advocated for by public staff be fair in light of the fact that the costs were incurred as a result of mandates from this commission?
Their position for disallowance would not be fair, given the mandate by the governor and this commission. Also, given the fact that we had experienced lost revenues, and also given the fact that, we were required to continue to maintain providing electric service throughout this entire pandemic.
Nothing further, Chair Mitchell.
All right. Few more questions from commissioners. Bear with me 1 minute. All right. Are you all familiar with the order of this commission issued in dockets number E-2 sub 1258 and E-7 sub 1241 on December 29th, 2021?
Yes,
Do you have a copy of that order in front of you?
I do.
Can you read to me the caption of that order? How is that order titled?
Order approving deferral request.
How did you all interpret that order?
We interpreted that order, that the commission, and I believe there's, that we were going to be considering the prudency of the costs in the next rate case.
So did the company interpret that order to approve the deferral request that the company had made related to the COVID-19 expenses?
Yes, we interpreted that you were approving it for the deferral treatment, and that we were going to determine the reasonable and prudency of our costs in the next proceeding.
So cost recovery would be addressed in a future proceeding, but this order that I've just referenced approved the company's deferral request. Is that correct?
Yes, that is my interpretation.
And that's the way the company interpreted the order and behaved accordingly, or took action accordingly subsequent to issuance of this order. Okay. Is that a yes, Ms. Bowman?
Yes.
Okay. All right. The yesterday there was an exhibit introduced that was an email exchange among a bunch of different people. But it was identified as DEP redirect COVID panel rebuttal exhibit number 1. And it was DEP potential cross exhibit number 17. Do you all have that document in front of you?
Yes.
Okay. So if you scroll down to what seems to be page 2 of the exhibit, there is an email, a body of an email that begins Jack, comma. We have reviewed DEP's supplemental responses to PSDR 138. Do you see the body of that email that I'm referencing?
Yes.
Okay, if you keep reading that paragraph, which I won't have you do, just follow along with me, please. There's a sentence that says, given the commission's position in its COVID deferral order and Commissioner Clodfelter's concurrence, we believe that if the company blah, blah, blah. All right. Given the commission's position in its deferral order and Commissioner Clodfelter's concurrence, do you all understand what that reference to Commissioner Clodfelter's concurrence is?
I am not exactly sure what this appears to be coming from public staff. Not exactly sure what they're referencing. I am.
Okay, that's a sufficient response. So when you all, and Ms. Bowman, I don't know if you were even copied on this email, so you may be seeing this email for the first time, but and I don't know if any of you were copied on this email or received this communication initially, but you all have since seen it, obviously. But how did the company interpret that sentence, given the commission's position in its COVID deferral order and Commissioner Clodfelter's concurrence? We believe that if the company cannot provide the public staff with a full accounting of its COVID costs and benefits in order to determine the net result of these costs and benefits, the public staff will be required to recommend denial of DEP's request to recover the deferred COVID costs. How did you all interpret that?
I mean, I think my interpretation is I disagree with the opinion that they have rendered. I don't.
You disagree with the opinion of the public staff?
Yes.
And what opinion is that?
That somehow they believe that a consenting opinion by Commissioner Clodfelter would require them in some way to deny deferral.
All right,
and
Ms.
recovery.
Bowman, you said consenting opinion. Did you mean dissenting opinion?
I think it was both a dissent and a consent.
Well, we could save that argument for another day, but I'm going to read the first sentence of the separate opinion of Commissioner Daniel G. Clodfelter that appears attached to that order. And the first sentence says, I do not join in the commission order in this matter because I am unable to discern exactly what the commission has and what it has not decided. How do you interpret that sentence?
I interpret that sentence to it's confusing that Commissioner Clodfelter by this sentence is not sure whether to determine whether or not the deferral should have been granted or not.
Okay. Does a separate opinion of a commissioner or multiple commissioners that's less than a majority carry the force and effect of an order of the commission?
No, it does not.
All right. So sort of, I won't ask the question again. So just, I will ask this question again, though, just so I'm clear, because it takes me a couple times usually to understand things. How did you all interpret the order that this commission issued in dockets E2 sub 1258 and E7 7 sub 1241 on December 29th, 2021, on your request for deferral of certain COVID-related expenses?
We interpret it as an approval of the deferral.
Okay. In my sort of research and review of the way in which COVID-related expenses have been treated in jurisdictions other than North Carolina. Obviously, this has been an issue we've been dealing with for several years now, and the ways in which jurisdictions are approaching costs associated with pandemic are sort of varied and of interest to this commission. So in my research, I've been made aware of certain regulated entities that have requested permission to defer net loss revenues associated with the pandemic or attributable to the pandemic. Are you aware of any such requests made by electric utilities in other jurisdictions?
To recover lost revenues.
Net loss revenues attributable to the pandemic.
You know, I haven't researched it that well to know off the top of my head. I'm sure that there are some. I think at Duke, we made a conscious decision to not include that. We realized the sensitivity of the pandemic to everyone involved. We would, in this case, just like to recover our costs.
Would it be a surprise to you if I said that there were other utilities in other jurisdictions that had sought to recover or defer and then subsequently recover net loss revenues?
It would not be a surprise.
Okay. Um, so can you repeat what I believe I just, let me say it this way. Did you just say the company is not seeking to recover net loss revenues associated with the attributable to the pandemic?
That is correct.
Okay.
We are seeking to recover bad debt expense and the fees that we've waived, and then a few other miscellaneous items that we've identified.
Okay. Is my understanding correct that the bad debt expense constitutes a significant percentage of the total amount sought to be recovered in this case, that you
Yeah.
all deferred and are now seeking recovery of?
Yes, that is the bulk. I think it's over 60%. And then you combine that with the waived fees and you get about 90% of the costs we're
Okay.
seeking to recover.
So just to make sure my understanding is correct, is it correct that bad debt constitutes a majority or more than a majority of the total amount sought to be recovered?
Yes.
Okay. Ms. Abernathy, you may have testified to this yesterday, and if so, I apologize. I'm going to make you testify again to it today. How much of the 107 million, which I believe is the number you gave me yesterday, total amount to be recovered in this case, how much of that 107 million is attributable to bad debt?
Approximately 60 million.
60 million. Okay. Makes sense. Okay. All right. Let's see. Ms. Abernathy, can you tell me, or anyone, can you tell me the level of bad debt expense and base rates
It's
or uncollectibles?
it's about 8.5 million for North Carolina retail.
Okay. Okay. And so the bad debt for which you seek recovery, the bad debt expense for which you seek recovery, just to repeat this point, is approximately 60 million in this case.
The 60 million represents the incremental over what's currently in rates that we have deferred during the COVID time period.
Okay, so understood. Okay. Let's see. There's been a lot of discussion about, I'm sort of walk through the company's response to the pandemic, kind of start to finish here, if you all would. So March 2020, state of emergency is declared. We recognize that there's a pandemic upon us, and we immediately have to take certain actions. Sort of walk me through what happened in the company's view, subsequent to the declaration of emergency in terms of provision of service and government mandates or orders of this commission that obligated the company to do things.
Sure, I'll start and then Ms. Quick can jump in and give more details. So I want to believe it was March 13th when our company made the decision for those that are not required to come into the office to stay home to conduct work. And it was at that point in time, I believe, that we started to be concerned about customers. And so we proactively, voluntarily said, again, realizing nobody anticipated this pandemic to last the length of time that it lasted. I think many of us were assuming a couple of weeks at home, maybe a month, maybe two at the, long range. None of us expected it to go as long as it did. So we voluntarily made the decision to waive non-paid disconnects at that point in time, and also some of the late payment fees. I think really it might have been the day or the day after that, in light of the governor's emergency order, this commission issued their order requiring all utilities, not just the electrics, but the gas and the water, and all of the utilities under your jurisdiction to stop and do non-pay disconnects and to stop any of the fees. And so we obviously had already had that in place, but we furthered that. And then we really began focusing on the company's transition to this kind of, I'm going to call it hybrid work environment for our company, because as I mentioned yesterday, we had 40% of our workforce that could not work from home. And we had to put the parameters in place so that they could safely work and continue to provide electric service throughout all of the pandemic. And I'm going to turn over to Leslie Quick to fill in some more details.
All right. So again, starting in March 2020, we got the state of emergency and the governor's order that required us to suspend disconnections for non-payment, and required us to not charge late fees for our customers. And that order was effective initially from March of 2020 until September of 2020. So in September of 2020, we were ordered that we could start back up our disconnections for non-payment. And so but we were still required to continue to waive the late payment charges. So at that point, I believe it was in November of 2020, we started returning to normal from a disconnection non-payment perspective. So
Did you say November 2020?
so that's when we
Is
began.
that a yes?
Yes.
Okay.
Yes.
Okay. Go ahead.
So we began disconnecting customers for non-payment at that point. At that same time, many of our customers had entered into our winter moratorium as of November of 2020. And so fast forward to the end of that moratorium, which around the February 2021 timeframe, we filed in docket 100 sub 158 after many discussions with public staff, NCJC, et cetera, to expand the winter moratorium to help more of our customers, our low-income customers. And so at that point, we got support for expanding the winter moratorium to customers who were actually eligible for light SIP. And then the commission even chimed in and added for our NC Hope customers. And so that would take place from February 2021 until March of 2022. So again, we were basically able to suspend about 60,000, between 50 and 60,000 customers due to that winter moratorium expansion for that time frame. and suspend them from disconnection for non-payment. And let's see, then we get to
Let me
August.
make sure I understand that last point you made. So there were between 50 and 60,000 customers for DEP
Yep, DEP North Carolina.
that the
yes.
company, North Carolina, that the company was able to suspend from disconnect for non-payment
Yes,
because of the expanded eligibility for the winter moratorium
yes,
on disconnects. Okay.
yes. So at the end of March 2022, the winter moratorium expansion ended officially. And so at that point, we had filed to auto enroll. And so any customers who were still in arrears at the end of that, to auto enroll them in 12-month payment arrangements. So, and a lot of the points around these enrolling customers into the installment plans was to, of course, suspend them from disconnection for non-payment, but also to allow them more time to get assistance. I mean, over these past couple of years, there was more supplemental funding that kept coming down the pipeline, as I would describe it. And so my team was working very closely with NCORE, I mean, almost on a daily, if not weekly basis, with NCORE to make sure that we were getting those HOPE funds to customers as efficiently and quickly as possible. So,
Ms. Quick, who is NCORE?
oh gosh, I don't know what the acronym stands for, but the CARES Act funding that went to NC HOPE was administrated through NCORE.
Okay.
So it was a kind of a third-party administrator of those NC HOPE funds. So at the end of March 2022, we auto-enrolled those customers in 12-month payment arrangements. And then fast forward to August of 2022, I think is when the state of emergency actually ended in North Carolina. And at that point, we could start charging late payment charges, but we could not charge them on any arrearages that were incurred either prior to the pandemic or during the pandemic. So that's part of the late payment charges that Witness Abernathy has spoken to. So really, as of August 2022 is kind of when we returned to normal operations around charging LPCs and continuing to disconnect for non-payment.
And when you say return to normal operations, you mean at that point going forward?
Right.
So then what was happening with the arrearages what was happening with the arrearages?
So the arrearages over that time frame from March of 2020 until August of 2022 were increasing. We were able to get our customers approximately $50 million in assistance in DEP North Carolina, but they were continuing to grow.
And I assume that during this period of time, some customers may have accrued arrearages may have accrued for certain customers, but then for whatever reason, they were able to pay down on those arrearages. Did that happen to your knowledge?
Yes, in many cases, customers were able to get assistance. I was seeing assistance be applied to these customers in dollar amounts that I had never seen before. Almost, some customers were getting $1,000 to help them get out of their arrearages.
So in those instances where the company received or payment from whatever, the customer was able to make payment on its obligation to the company, and was able to do that for whatever reason, be it they got money from a third party assistance source or just made payment. The company has updated its uncollectibles accordingly, right? I mean, you all aren't trying to recover monies that the customers have already paid you.
Yeah, that is correct.
There's no double counting going on. There's no effort to try to collect what you've already collected.
That is correct.
Okay.
And quite frankly, I think the work that Ms. Quick and her team did during the pandemic to try to take advantage of all the federal funding and state funding available helped significantly reduce the amount that we're asking to recover here.
And Ms. Quick, I heard you say $50 million. When you said $50 million, is that, help me understand what the $50 million is.
The 50 million in assistance was customer assistance from third parties that our customers got between the 2020 timeframe and then to date.
Is that for DEP and DEC?
That's just for DEP North Carolina.
Just for
customers.
DEP North Carolina is 50 million over that March 20 through August 2022 timeframe.
Right.
Okay. So let's kind of go backwards to March 2022. March 2022, Ms. Quick, you testified that you all began the auto enroll and the payment arrangements. Just explain what that means.
Yeah, so many of the customers in the winter moratorium, right, if you reflect back, they had really been suspended from disconnect for non-payment since November of 2020. And so many of those customers, many of them sought assistance. Many of those customers were still in arrears at the end of that March 2022 timeframe. We were still in the state of emergency. And so at that point, the company felt like to further support those customers in need, that we would give them an additional 12 months installment plans to help them kind of levelize those payments and make their payments more realistic going forward, given that we were still in the state of emergency. And that was all included in the docket 100 sub 158.
And can you sort of give me a view into the status of those payment plans? Because as Mr. Mehta pointed out yesterday, or I believe it was yesterday, sort of March 2022 and March 2023. I mean, we have a sense of how much of those payment plans have been paid down and how much, those which have not. So you walk me through that?
Yeah, I don't know that I have exact numbers, but I would say approximately 50% held current on their installment plans. And so the remaining customers are still in arrears, which is creating the bad debt that Ms. Witness Abernathy has discussed.
The 60 million?
Yes, that's how much we have deferred.
So what happens to those customers who at the end of that, of the 12-month period, were not able to pay off what they owed the company?
They would be going back through the credit and collection cycle. And so if they weren't able to hold true on their payments with their current bill and the installment plans, we would consider that a default, and they would go back into the credit and collection cycle.
Do you have a sense of how many customers that is? I mean, I know you've indicated you don't have a specific numbers, but rough approximation?
Reflecting back to some data request responses. And so I don't know that I have that number memorized, but I want to say, I'm not exactly sure. I would have to look that up.
Okay. Okay. The yeah, I want to talk some, I want you guys to explain to me the tightening the belt measures. That's how you all have described them. So help me understand what those measures were generally and why they were instituted by the company.
So I can start. So during 2020, as we've explained, we had, the net lost revenues as a result of COVID, but we were also faced with mild weather in that year, as well as incremental storm cost. And so the company put in place many different cost efficiency measures that we would do any year when faced with revenue challenges, just really looking at where there are opportunities to look at scope of work to be done, shifting timing, really looking at headcount, things like that, contingent workers, those type things, to see where there's an opportunity to produce those savings. And we were able to achieve some of those savings to address both the mild weather and the impacts of COVID on our load. And I apologize, my allergies are crazy, so I
That's
keep
okay.
having to cough.
That's okay. If you need a minute, just let me know and we'll take a minute. So if you all hadn't instituted the belt tightening measures, what would the company have had to do?
I mean, we would have a challenge meeting some of our earnings targets.
And how, and sort of following that through, what does that mean? And what happens as a result of not meeting earnings targets?
So it would have negative implications to the financial health of the company. It could potentially, I'm not the finance expert, but we could get downgraded, and then it could cost our financing costs could increase.
And if your financing costs increase, what does that mean for your customers?
It flows down to the customer, so it's not a good thing for the customers if our credit metrics are to get hurt.
So let's go back to the public staff's position here. Ms. Bowman, you testified yesterday about there's a difference of opinion between the public staff and the company. In your view, in the company's view, what is that difference of opinion?
I think the difference of opinion is the interpretation. I think the public staff is trying to say all of the belt tightening that we did during this period should go towards savings related to the pandemic. And we disagree. We do not believe that is the case. We believe we have identified those savings that is in the witness Abernathy has testified to that are related to the COVID, but it should not be the breadth of that.
And so just to make sure I'm clear on the company's accounting here, the company is it correct that the company has identified savings that are attributable to COVID
Yes.
and has reflected those savings in the total amount of the total amount requested for cost recovery in this proceeding?
Correct.
Well, I would say that those savings directly related to COVID have partially offset the net lost revenues due to COVID and made it so we did not have to request for recovery of those net lost revenues.
So let's talk some about the net loss revenues. And Ms. Bowman, you just testified to this a minute ago, or we were sort of you were testifying about this a minute ago, but I want to make sure I'm clear. So you experienced, as I understand your testimony, and correct me if I'm wrong, in 2020, the company experienced NLRs related to COVID and mild weather and incremental storm costs. Do I understand that correctly?
Yes.
Okay, and so, as I understand the testimony you just provided, the company used the savings attributable to COVID to offset the net loss revenues attributable to COVID. Is that correct?
Yes, it partially offset.
Partially offset. So the company then, I am led to conclude, and you all tell me if I make this conclusion incorrectly, that the company was able to identify NLRs attributable to COVID.
Yes.
Okay. Let's say you had asked, let's say you had, I'm trying to understand the impact to the company and then ultimately its customers of these NLRs. If you all hadn't been able to offset NLRs, COVID NLRs was through savings, what would have happened to the company? What actions would the company have had to take?
Well, we likely would have requested recovery in the deferral as well for those lost revenues.
Okay. And was there any other alternative to the company for recovery of those NLRs, alternative to deferral?
Not that I'm aware of.
Okay.
Not at that point in time.
Okay.
I believe we were already in a rate case at that point
Well,
in time.
and the NLRs, again, if not addressed through cost, well, let me just, again, help me understand the impact of the NLRs to the company.
So net lost revenues represent fixed costs that we've incurred. There are fixed costs that have not been recovered due to lower revenues coming in.
Okay, so ultimately, if you're not able to offset those lost revenues through savings, what is the impact to the company of those lost revenues?
Well, it's a financial hardship, and it could drive you into the need to file a rate case.
Okay.
You
Could it
know,
also result in earnings degradation?
Correct. and everything that we just previously talked about.
Which is what?
It would impact, the financial status of the company. We could have credit ratings drop, and then, our ability to raise capital at good rates would have to go up, and therefore impact our customers.
Ms. Quick, the work that you all did during this period of time, 2020 through 2022, 2023, to provide assistance to customers that needed assistance with their obligations to the company. Was that an endeavor, an exercise that was unusual for the company, or was this the first time the company had to take the kinds of steps you all were taking?
This definitely was the first time, due to the unprecedented nature of the pandemic, that we went really above and beyond to get our customers assistance. And just the fact that there was a lot more funding available for our customers. And so we knew that during this time, with all the additional funding available, we had to get it to our customers as quickly and as efficiently as possible.
And so did that mean the company had to take measures that it hadn't previously taken? Meaning take action to ensure that those monies got to customers, were applied to customer accounts?
We do that in our normal course of business, but I will just say, with the additional funding that was available, we had to dedicate more resources
Okay.
to get the funding to our customers.
Okay, and you said ultimately, let me get my notes back out, 50 to 60,000 customers. Hang on, let me see what you said about 50 to 60,000 customers.
Those were the customers auto-enrolled or
Okay,
into
that's
the
right.
winter moratorium.
That's right. So how many of the 50 million that you all were able to, $50 million in assistance that you were able to connect DEP North customers with, how many customers roughly benefited? Can you give me a ballpark?
I don't have that specific number,
Okay.
but a lot of customers.
Okay. Well, $50 million is a lot of money, so let's, all right.
I also think that we were seeing customers that we don't normally see struggling throughout the pandemic. I mean, it was extraordinary and it was unprecedented, like nothing we've ever seen. So some
Wait,
individuals.
Ms. Bowman, let me stop you. When you say that, it was extraordinary, it was unprecedented, like something we've never seen. What do you mean specifically?
So we've never, as a company, we've never experienced something quite, I mean, everything kind of shut down, Remember, movie theaters were closed, gyms were closed. People were scared to go out. I think some people lost jobs, some people stopped working. I think it had everybody a little bit scared. And so for the first time, customers that we don't typically see experience financial hardship or non-payment, we're starting to experience non-payment and financial hardship. And I'm looking at witness
So-
to verify.
So Ms. Bowman, do I understand you correctly then that that DEP, North Carolina, had a larger number of customers in trouble with their obligations to the company than you all had experienced prior to the pandemic?
Yes.
Okay.
And, many of our customers were going through different scenarios, obviously. And I think the one that I testified to in my direct was just related to a couple. The spouse died and the husband had never had to search for assistance before. And so we were able to connect that customer proactively. We reached out to them. He didn't even realize he would be eligible for assistance and were able to help him avoid a disconnection for non-payment just by getting him assistance. So there were a lot of our customers who had never had to seek assistance before.
Okay. All right. Let me see if there are any additional questions from commissioners. Let's see, Commissioner, let me go through this. Commissioner Brown-Bland, Commissioner Klinefelter.
I think probably, Ms. Abernathy, this is probably best for you, but others can chime in as they need to. I need to unpack, just to be sure I'm following the numbers. I want to unpack some numbers. Now, I get, and let me say as a preface, I get it that the company is not asking for recovery of net loss revenues, but still there's been so much talk about it. I get lost in the numbers. Net implies that there's a gross and then a reduction to get to the net. And that's where I'm not sure I'm tracking the testimony clearly. So I want to be sure I am. Just to know the amount we're talking about that the company is not requesting. And so I'm going to use pages 35 and 36 of your rebuttal testimony, the panel's rebuttal testimony. And I understand on those two pages, you're using 2020 only as the illustration. So that would not give me 2021 or 2022. I understand that. But if I get the calculation for 2020, then I know how to apply it to the numbers for 2021 and 2022. So I start off with what's the gross? I'm elementary. I have to start with the gross before I get to the net. So the gross combined, you say on line 21, page 35, the combined impact of reduced load and increased storm costs is approximately 85 million for 2020 on a North Carolina retail basis. And then you did the belt tightening cost saving measures, which realized approximately 6 million of system savings, of which 62 million is the North Carolina retail portion. So that gets me to a net loss revenue of 23 million for 2020 North Carolina retail portion. Now I get finally to my question. What you've identified as the COVID, specifically identifiable COVID savings, were they then applied to offset the 23 million, or are they embedded in the 62 million?
Those are part of the 62 million. This was just an example to show if you were to incorrectly assume that all savings were related to COVID, what would the impacts, and to show that even with all of the savings measures we put in place, we were not able to outstrip it, but those would be embedded in that number.
Okay, so that's not an additional deduction from the 23 million to get to a final net.
Right.
It's embedded in the 62. Is there some place in your rebuttal testimony or elsewhere where I can see what portion of the 62 million are those specifically identifiable COVID cost savings as opposed to the general belt tightening you talked about?
The COVID, the specific savings related to COVID are about 4.5 million. And
Okay.
That is discussed earlier in the testimony.
It's back earlier in the testimony. I have to pick that up and then bring that down when I'm reading the 62, 85, and 23. You've helped me follow the flow, and that's what I needed. Thank you.
Okay.
All right, Commissioner Duffley.
Mr. Durant, could you take these to the witnesses, please?
Consolidated for that last case.
Ms. Keyworth, do you want to see what I've handed the witnesses? Okay, welcome back. So I heard some things yesterday, and I wanted to clarify the record on a few matters. So do you know who Mike Manus is? Are you familiar with Mike Manus?
I am familiar with Mike Manus.
Who is Mike Manus?
He is the former director of the accounting division for the public staff, and he is now retired.
How long do you think he worked for the public staff estimation?
30 years? I don't know.
Okay. So I've handed you a couple of pages. Are you familiar with the DEP consolidated hearing for DEP's rate case in docket number E-2 sub 1219?
Yes.
Okay, I've handed you page 39 of the consolidated hearing transcript volume 7 dated 8/27/2020.
Yes, I see that.
Okay, could you read for me the question and answer beginning on line 11?
So it's always part of the public staff's analysis on deferral decisions to look at the impact on the company's financial condition and see what the impact on earnings and rate of return on common equity. Do you always look at those in every single case?
And the answer?
I wouldn't say it would be every single case. For example, there are some that are essentially written into law or written in commission rules that you're going to allow deferral accounting, like fuel, DSM, that type of thing. There are others where the deferral accounting may simply be appropriate because it's better accounting and better rate making. And the one of those items in dispute in the rate case is with the sale of the hybrid units. Do you want me to continue?
Continue.
Our recommendation is essentially that deferral is appropriate because deferral and recovery over future years is just better rate making than simply having it totally absorbed by the company in 1 year or writing it off in 1 year. We're just arguing about how many years should it be at this point on that issue. So there are a multitude of reasons, different items are brought up for deferral. Another one is that I think of is a new generating plant where the overall intent is both to act as a sort of a proxy for interim rates and at least effectively synchronized for an earnings standpoint. The date the new rates go into effect and the date that the plant goes into service, even though physically they are different things. But we can employ deferral accounting in those cases because really the plant may be driving the rate case. And so it makes sense to defer the cost of the plant going into service until the rates take effect. So in those types of cases, magnitude sort of takes a backseat to other considerations. But in a case like this,
And that's fine right there. And then I've also handed you page 83 of the same transcript.
yes,
So on the previous page, on page 82, the question was, so you would agree that the reason sort of intuitively that the commission can, in its discretion, authorize a different test in the context of a general rate case Is that because when deferral accounting is allowed as part of a general rate case, it's not really single issue rate making problem, right? And he answers this question. So did I hand you page 83?
I have page 83, so I can,
Okay, so he answers this question subject to check. I think that there's a qualitative difference in the way you describe, and he continues on with that answer. And then if you could start reading from line 3.
so I think you're right. They're considering the decision in the context of all other rate-making decisions. But I think it still is a decision to go down a path that implies a certain amount of single issue accounting and rate making. It's just a decision being made in the general rate case. To sort of illustrate, the commission could, at least from an accounting perspective, I don't know from a legal perspective, the commission can establish a different so-called test for deferral accounting in the context of a petition for deferral accounting that's occurring outside of a general rate case. I don't think there's any requirement that it be a general rate case for them to redefine or refine or do something else to test to whether deferral accounting should be allowed.
Can you read the next question and answer?
The next question is, so then the commission's discretion is actually even broader than I just described. Answer, I think so. I'm not going to state a legal opinion here, but it seems to me that since the commission has approved deferral accounting itself outside of a general rate case, that the commission can decide what test is appropriate to determine outside of a general rate case if deferral accounting should be approved.
Okay, thank you. So turning back to the DEP potential cross exhibit 17 on page 2, Chair Mitchell asked you about this. So can you read again the answer on page 2, or the statement by public staff beginning with the word given?
Given the commission's position in its COVID deferral order and Commissioner Clodfelter's concurrence, we believe that if the company cannot provide the public staff with a full accounting of its COVID costs and benefits in order to determine the net results of these costs and benefits, the public staff will be required to recommend denial of DEP's request to recover the deferred COVID costs.
Okay, have I handed you the commission's order?
Yes, the order approving deferral request.
Correct. Can you find anywhere in the majority opinion this requirement?
No, I cannot.
How is the opinion styled? What's the name of the order?
Order approving deferral requests. And I believe it couldn't be in conclusion, the commission will grant the company's request that estimated incremental costs of utility service that are approximately caused by the pandemic may be deferred pending the final determination on cost recovery in a future rate case.
Can you go to page 11 of the order?
Yes.
Can you read the sentence beginning with consistent on page 11?
Consistent with the company's request, the commission's approval of the company's deferral request does not authorize recovery of such costs now or in the next general rate case.
And the next sentence?
As the companies correctly note, the question currently before the commission is only whether the companies may create a regulatory asset to include the estimated incremental costs due to the pandemic, including carrying cost at their weighted average cost of capital, not recovery of those costs.
With respect to the second sentence you just read, how do you interpret that sentence?
So I interpret that sentence that the companies could create their deferral, including our WAC, and that the determination of the recovery of those costs would be in the next proceeding.
What was the question before the commission that was approved?
The question was if we could create the regulatory asset, the deferral of the COVID costs and the weighted average cost of capital. I will also note that this commission said this was a unique circumstance. I think others have brought up the two-pronged tests that we were just discussing from, believe it was witness maintenance in the last case. And that is, on a case-by-case basis, it does not have to apply in all circumstances.
Give me 1 minute. So subject to check, would you agree that the majority opinion states when determining a deferral request, outside of a rate case, the commission sometimes, but not every time, applies a two-pronged test to determine whether or not to approve the request for deferral?
Yes.
Okay. Did the majority opinion discuss the two-pronged test?
It did.
If you could turn to page 9 of the order.
I'm there.
Oh, and that actually, could you read in the first full paragraph, the exact language at the second sentence?
The commission, while generally applying a two-pronged test when judging deferral request, has considered each request individually on a case-by-case basis.
Okay, and can you read that first sentence?
The commission agrees with the companies that the deferral requests, by their nature, are unique.
And then can you read that last sentence that begins, in this case?
In this case, however, the commission agrees with the AGO that the fact that the deferral request was filed during the pendency of the rate cases does not moot the relevance of the second prong of the test, especially as the costs sought to be deferred are ongoing and their total cost unknown, and they were not included in the consideration of rates in those cases.
And does the order then discuss the second prong of the test?
Yes.
And then if you could turn to page 10. If you could read the sentence beginning with thus.
Thus, while it is possible that the impacts in this case would be material for the purpose of considering the second prong of the commission's deferral test, the commission cannot reach a conclusion on that point because the actual amounts sought to be deferred have not been determined. However, because of the extraordinary and unprecedented nature of the pandemic and the continuation of the governor-declared state of emergency, the commission will allow the requested deferral in this case in order to provide the companies an opportunity to capture the estimated incremental pandemic-related cost and to seek recovery of such cost in the company's future rate cases.
Okay, thank you. Can you turn to page 20 of your rebuttal?
Yes,
And on page 20, there's a footnote 9.
yes.
If you could read, it's about 5 or 6 lines down, the sentence "in deciding."
In deciding in favor of allowing the deferral requested by the company, the commission largely sidestepped the issue, rendering it moot.
What sidestep? What issue do you believe was sidestepped?
I believe the issue of considering material impact.
After reading the sentences within the order, do you stand by that testimony?
I believe it's not necessary. I believe we've determined that this is unique and extraordinary, and we're now in the context of a rate case.
Okay, after a deferral outside a rate case has been granted, typically do the parties apply again the two-prong test in a rate case when determining cost recovery and amortization of the deferred cost?
You know, I think by the nature of us filing a rate case is our earnings are below. I'm looking to witness Abernathy on here. So I believe we automatically meet that prong of the test.
Let me rephrase. When the commission determines a deferral outside of the rate case, do they typically employ a two-prong test?
And not every case. I think it is on a case by case basis.
Okay, but just let's say, not in this case, but in another case where the two-prong test is applied outside of a rate case.
There have been cases where the commission has looked at both prongs. Yes.
Okay, so the two-prong test is a test to determine, would you agree or not agree, that the two-prong test is used to sometimes outside of a rate case, used to determine whether a deferral will be granted or not.
That is correct.
Is that two-prong test again looked at when the costs come for cost recovery in the rate case?
I do not believe it. I mean, I do not know whether it needs to be looked at again. I think it's.
Has the issue already been decided in the deferral order?
I think the determination that it was extraordinary and unique has been determined, and therefore the deferral request was granted. Now, in the context of the rate case, we are looking at the prudency and reasonableness of the costs.
Okay, thank you. I have nothing further.
Commissioner Hughes, and then McKissick, and then Kimmerer.
Thank you all for explaining the big picture. I think I got the big picture. But I want to go in the weeds a little bit to understand where the numbers are coming from, kind of going up to the big picture. And if I could just ask a series of questions related to kind of the moratorium, late fees, payment plans, when they're booked. So I think it's going to make the most sense just for me to give you a single customer example. So a customer goes into the normal moratorium with $100 balance on their bill. So November, December, I know we have timing related to when it hits, but they go into the normal moratorium and they fit into the restrictive sort of normal winter moratorium criteria, which I don't think encompasses very many customers. In fact, do any of you offhand know in order of magnitude how many customers would have been in that moratorium going into the pandemic?
Typically less than 100.
Okay, yeah, so hardly any. Okay. So somebody goes into that moratorium with $100. You can't cut them off. Walk me through how is the late fee typically addressed in that situation? So first month goes, you don't cut them off. I think it's a 1% late fee. So then it's an extra $1 gets added to their arrearage. The next month occurs, another $100. They don't pay. You can't cut them off. Is there another late fee that is then put on their bill based on the $201 balance? So then is there another 1% of that balance added on their bill the second month? Does that make sense?
Yeah, I guess they would continue to accrue late payment charges.
Okay, so even under the typical moratorium previous to the pandemic, there would be late charges. Then when they would come out of the moratorium, then you would address, they might have, they might have a outstanding balance of 4 months, $400 plus $7 or whatever of late fee payments. Then you would address collecting the $407. And if they couldn't do that, the option would be either cutting them off or putting them on a payment plan. Is that?
Generally, yes, and they could also find assistance also to help them. Yeah.
Okay, so, but those late fees by that point are in arrearage, and so they're now a candidate for bad debt. They're no longer, that's where they're showing up.
Yes.
Okay. So under the expanded moratorium, when there also is a prohibition about late fees, a lot more people than 100 go into that. It's spread over a lot more time. Did you book those late fees just like you would under a normal moratorium, but you just didn't add them to the customer's account? You kept track of them. So for my example, at the end of 4 months, it would have been the amount due would be $400, but then you would have this $7 in kind of late fees that you were keeping track of, but that are not on the customer's arrearage, but you are looking at as sort of foregone revenue. Is that the way it's all working out?
Yes, so we were looking at the outstanding balances for these customers and when the late payment fee would actually be applied to the customer's arrearages. And so we were able to calculate that out of our system, the numbers that our system produced. We calculated the late payment charges that would have been applied.
So when we gave you the authorization to do the deferral, was the dollar, roughly $1, 1% of the balance, was the dollar of late fees going into the regulatory asset account month by month? So, in December, $1 would get shifted into the regulatory account. And then in January, another $1 for this one customer, another roughly $1 would get shifted into the regulatory account. So it was kind of month by month building. Is that how it was done? Correct. And then once it was in the regulatory asset account, then again, based on our order, it was getting the weighted average cost of capital added to that. So then we have the split off where the arrearage is sticking with the customer, but then the late fees are in the regulatory asset account, and they're building and getting the weighted average cost of capital added to them. Do I have it right?
Correct.
And if somebody is put onto a payment plan, either during a moratorium, I don't know if it's customary to be negotiating payment plans just under normal circumstances during during a common moratorium, or whether you kind of waited until afterwards. I know with the pandemic, we had specific rules about payment plans, but just in general, if somebody's put on a payment plan, what happens to the late fees? Do those get frozen, or do they get continued to be incorporated into the balance of the normal payment plan? Does that make sense?
Subject to check, I believe they still get charged on their arrearages, but I would need to look at that.
Okay, yeah, that'd be really interesting to me to know if somebody, has a extended payment plan, is that 1% getting added, and does it get added to their arrearages, or, and then under this circumstances, and you had a lot of payment plans that you had to get into. So I think it would be interesting to know when you set up those payment plans, those lack of late fees couldn't have gotten added to the arrearages. So I guess it was just the same way you were treating it as we answered before. It was just going into the regulatory asset account as it was being built. Is that built up? Is that right?
Correct.
Yeah, I think that thank you very much. I just trying to follow these dollars has been very tricky. I think that's, and if you could, if your answer is different, then if you find out that it's different, then by all means, submit a late file exhibit, I guess. But if it's not different and you're correct, then I don't know what the process is, but that's fine. Okay. Yeah, I think that's all. Thank you.
All right, Commissioner McKissick.
Well, first, I want to thank you for your testimony yesterday and today. And I just want to make sure I got the issues as you best see them. And based upon what I reviewed before coming in here and hearing a word of your testimony, I mean, essentially, Duke's position is that in terms of true savings, as a result of COVID, you look at the reduced printing cost, you look at postage, you look at travel expenses and things of that sort, and you came up with about $4.5 million. Is that a correct assumption to make?
That's correct.
On the other hand, public staff is saying, hey, it's like $96 million or so. And is that correct?
Yes,
And essentially, you will say that you're not, I think I read the question yesterday about net loss revenues, and you will, Kendall and Ms. Bowman indicated that you were not planning to request net loss revenues.
Correct.
And in terms of the stipend, I know yesterday there was some discussion about the stipend, but from what I reviewed and looking back over the testimony, basically public staff's position was the stipend that went to employees was essentially goodwill, and it should come from shareholder money as opposed to being recovered somehow. Is that a correct assumption? Because I don't think that's what was stated yesterday on the record.
I believe that's how public staff referred to it in their testimony.
Right. That's the way they felt it should be handled, and you all disagreed with that assessment or conclusion.
Correct. And I believe yesterday we explained why we felt it was important to issue that in light of the pandemic for our employees.
And to be honest with you, when I go through this and listen to your testimony, when I have to digest it and kind of look down to simplifying the issues, those are the ones that are out there in my mind. I think the order the majority issued originally dealing with deferral, we could take notice of it and it kind of speaks for itself and could save some time. Thank you.
I have just two follow-up questions to get a little bit more specificity from questions that Chair Mitchell had asked. And the first one relates to testimony about the tightening the belt testimony, the measures that were taken beginning in 2020 related to reduced revenues from COVID and mild weather. And on page 34 of the testimony beginning on line 15. I'll just read the sentence. It states that I will note that for DEP, the largest of the financial impacts the DEP was attempting to offset with these cost efficiency measures was mild weather, not reduced load and NLRs from COVID. To get a little bit more specificity, is there a percentage or a little bit more specificity that you can provide about talking about the largest of the financial impacts?
So yes, we've estimated that the North Carolina retail revenue impacts in that time period due to both COVID and weather were approximately 71 million. And of that, $42 million attributable to weather and then $28 million attributable to reduced load due to COVID.
Okay. Thank you for putting that on the record. And then on page 30 of your testimony, you provided information about the net lost revenues in 2020. And beginning on page line 17, you stated that in 2020, the company estimated approximately $4.5 million on a North Carolina retail basis and O&M expense savings attributable to COVID-19, and that the NLRs were approximately $28 million. Do you have those numbers for 2021 as well?
I do not. I know the savings directly attributable to COVID, those were primarily incurred in 2020.
Okay.
And then also net loss revenues due to COVID, you know, things started to pick back up in 21. So I don't have those numbers handy.
Okay, so in other words, 2020 is the year that is particularly important for the net loss revenues and the savings, as opposed to 2021.
Yes,
Is that-
2020 was the most significant impact with regards to that.
Okay, thank you.
Yeah, there's one, I knew there's an angle that I didn't get clear in my head. So I know when the late fee, back to the same example we were talking about, when the late fees, either not paid late fees or not assessed late fees, got into the regulatory asset. Help me understand when the bad debt got into the regulatory asset. So for that particular customer, the example was building arrearages, you know, and through the pandemic, it was just month after month of arrearages. Say, you know, the arrearages got up to every month was getting $100 added to the arrearages. When, for bad debt purposes, when did those arrearages, when did they get moved into bad debt? Was it way at the end of the pandemic, or were you keeping track of the arrearages for customer A that they were building month by month, and then eventually it all got switched over to bad debt, but you kind of booked it month by month, or does it go over as one number? I know you understand it. Probably nobody else in the room understands what I'm doing. So go ahead, please.
I do. Let me see if I can try to answer that for you. We do a reserve estimate quarterly, and that's to estimate how much bad debt expense we expect based on the arrearages. So we're booking it along the way, and then eventually, if a balance gets charged off, that's when the adjustment goes through the reserve the opposite way.
Okay, and if it gets paid out, or you receive
We would
payment from
adjust the
some
reserve up or
source,
down
then
for
it
those
reduces.
reasons. Yep. I'm sorry.
I'm sorry.
We would adjust the reserve up or down at that point in time.
Okay, thank you.
All right, questions on commissioners' questions. We will start this side of the room. Any questions?
Just one, and it's a very specific clarifying question to Ms. Abernathy. In response to Mr. McKissick, Commissioner McKissick's question about the $96 million that the public staff identifies, that's on a system basis, correct?
Yes, that was the system.
And on the North Carolina retail basis, that equivalent number is $62 million.
That's correct.
That's all, Chair Mitchell.
All right, we have come to the end of this panel's testimony. You all may step down.
Chair Mitchell, the company would move the introduction into evidence of DEP redirect COVID panel rebuttal exhibit 1.
That motion is allowed.
Thank you, Chair Mitchell, and we're going to do a little musical chairs here, so give us a moment.
So,
And actually, we will, go ahead, Mr. Dirac.
thank you. At this, next up on the witness list is Miss Leslie Quick. She presents a very narrow scope of rebuttal testimony on a very narrow topic in the case. No parties have indicated that they have any cross-examination for her, and if the commission does not have any questions for her on that scope of her rebuttal testimony, we would ask or make a motion to excuse her, but I wanted to just confirm first whether any of the commissioners have questions for her rebuttal testimony scope.
Any questions for Ms. Quick? Commissioners? All right, looks like there are no questions, so I will allow your motion. And would you like to go ahead and move her rebuttal testimony into the record?
Give me one moment, sorry. Credit card. That's what we're talking about. Yeah. Okay, thank you, Chair Mitchell. So yes, we would move that Ms. Leslie Quick's rebuttal testimony be moved in the record at the appropriate time and that Ms. Quick be excused from appearing.
All right, the rebuttal testimony for DEP witness Quick filed on April 16th, 2023, consisting of 8 pages, will be copied into the record as if given orally from the stand.
Thank you very much.
All right, Ms. Quick is not excused because she will appear with the affordability.
I apologize. She's so critical to our case that she just can stay there the rest of the hearing, I guess.
All right, so let's call the next, actually, let's take a break. Let's take our morning break. We'll be back on the record at 11:15. We'll be off the record. right, I remind the panel that you all remain under oath.
Chair Mitchell, we have one witness on the panel who is appearing for the first time and hasn't been sworn.
Oh, I'm sorry, Ms. Barnes. All right. Let's see. Raise your right hand, please, ma'am. Left hand on the Bible. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right.
Josh Combs for the record. Ms. Barnes, could you please state your full name and business address for the record?
Yes, my name is Kenisha Barnes. Business address is 526 South Church Street, Charlotte, North Carolina.
And by,
02.
oh, sorry. And by who are you employed and in what capacity?
Employed by Duke Energy, and I'm the Energy Policy Director.
Okay. Ms. Quick, could you, even though you've already testified, could you just please state your name and address for the record?
Leslie Quick, 526 South Church Street, Charlotte, North Carolina.
And Mr. Harris, could you please state your name and the business address for the record?
Bradley Harris, 411 Fayetteville Street, Raleigh, North Carolina.
And Ms. Barnes, it's correct that you have not previously filed testimony in this docket, right? Direct testimony in this docket. Okay. On April 14th of this year, Ms. Barnes, did you file or did it cause to be pre-filed 19 pages of joint rebuttal testimony in question and answer format?
Yes, I did.
Are there any corrections that you need to make to that pre-filed rebuttal testimony?
No, there are not.
If I were to ask the panel the same questions today under oath, would your answers be the same as set forth in that pre-filed rebuttal?
Yes.
Yes.
Ms. Barnes, on May 5th, 2024, did the panel cause to be filed an affordability settlement testimony consisting of 7 pages?
Yes, we did.
And if I ask the same questions today under oath, would your answers be the same as set forth in that pre-filed settlement testimony?
Yes.
Did the panel also prepare a summary of your rebuttal testimony and cause that to be filed on May 3rd, 2023?
Yes.
Okay. The summary was pre-filed on May 3rd, and I just asked Chair Mitchell that it be included in the record as if given orally on the stand today. The panel, it's my understanding that all parties have waived cross-examination, so the affordability panel is available for commissioner questions.
All right, let's see. Have we moved their testimony into the record?
We have not.
Okay, let's do that. I'll take a motion from you.
Yes, Chair Mitchell, I would ask that the affordability panel's testimony filed on April 14th in docket number E-2 sub 1300 consisting of 19 pages be entered into the record.
All right, the rebuttal testimony of the affordability panel filed in this docket on April 14th, 2023, consisting of 19 pages, will be copied into the record as if delivered orally from the stand.
Chair Mitchell, I would also ask that the settlement testimony of the affordability panel consisting of 7 pages filed on May 5th, 2024 be entered into the record.
All right, the settlement testimony filed on behalf of the affordability panel in this docket on May 5th, 2023, consisting of 7 pages, will be copied into the record as if given orally from the stand. And the summaries of the testimony provided on behalf of this panel will also be copied into the record as if given orally from the stand.
Thank you, Chair Mitchell. The panel is available for commissioner questions.
All right, let me see. Commissioner Brown-Bland, Commissioner Clydfelter. All right, definitely Hughes, Commissioner Hughes, go ahead.
Yeah, I have a question about the pilot status of the potential customer assistance program. I'm a big advocate of experimentation and piloting, and I'm glad both for this, it's at least on the table for this case, but as well as a lot of Duke's other pilots. But for any of these pilots, and I didn't see it in the record here, I might have been missing it. What could you give me 2 or 3 bullets of what is a success going to look like in a pilot? So, we do something, say we do it for 3 years, it's either going to be a success or, failure or somewhere in between. So could you just give me a couple kind of qualitative bullets, but then more specifically, we've entered into this age of discussing a lot about metrics and measures. Can you give us a handful of actual measurable quantifiable metrics that we can be tracking along the way, not just waiting until if it goes ahead, not just waiting until 3 years out, but what are some metrics that we could be looking at and shaking our head that that's in a good direction or a bad direction?
I appreciate the question. It's a really important one. In the LIAC final report, there are several general success metrics that are across a lot of affordability programs, but would definitely apply to CAP. And I'll just briefly summarize them if I may. This is on page 39 of Harris Exhibit 1, my direct testimony. Minimize barriers for customers to participate, significantly and sustainably help participating customers, low administrative cost of operation of the program, minimize bill impacts for non-participants, and generally being eligible for cost recovery. So I think as a group in LIAC, we've gotten together, and as you can tell, these are rather broad metrics, and we can further discuss. I think the settlement sets the stage, and the cooperative discussions that we've had for further discussion. But I think that really lays out, we want to make sure that we're helping customers significantly and that we're doing that efficiently, keeping administrative costs low because that benefits everyone, and ultimately seeing if we can measure the success of the program in terms of helping customers stay more current on their bills.
Commissioner Hughes, and I think just to add to Witness Harris' comments, the other thing that I would share is that even though CAP is a bill pay assistance program, one of the things that we have been committed to doing in conversations with low-income collaborative members is we have this recommendation that also after customers who get CAP are approved for CAP, then they also would be recommended for energy efficiency. So I think one of the success measures is what percentage of these customers who are enrolled in bill pay assistance through CAP also are able to receive weatherization or energy efficiency services that will not only help them. CAP helps the customers from 1 month to the next as far as lowering their bill. But as we all know, the weatherization or energy efficiency programs, that right there is going to provide long-term benefits where not only does it help reduce their bill from 1 month to the month, but they have these long-term savings that are incorporated as a result of being able to participate in our energy efficiency and weatherization services. So I think the other piece is another success metric is us being able to look at what customers are participating in CAP, what percentage of those customers are actually able to receive weatherization services? And if the customer is not able to receive weatherization services, what are those barriers? We've talked about a number of those barriers in the LIAC. One of those is health and safety. 40% of customers who would be eligible for weatherization today don't receive those services because there's some type of health and safety investment that is a barrier for them participating. So I think in addition to what Witness Harris said, there are a number of other things from a weatherization, just kind of really connecting those dots so that we have an opportunity that we can measure.
Well, I appreciate that. I think the answers seem to be kind of jumping back and forth from some of the objectives and some of the measures. And I was trying in my head to kind of just see what was the number that I was going to look at. And I wasn't sure I followed for all of that. So I do urge you, if we go ahead with this and with any pilot project in general, to work with public staff to have just a series of numbers. I like, what you've said made sense. The objectives made sense, but I'm still not sure exactly what numbers I'm going to be looking at. And you have lots of numbers and a great customer information system. So I look forward to both for this one, if it goes forward, but also for others to just see more information, and hopefully not waiting until the very end, but kind of periodic. Thank you.
You just said 40% of customers. Do you remember referencing 40% of customers? 40% of customer. Give me that statistic again.
Yes, I'll be glad to. So when we were doing work in the Low Income Affordability Collaborative, and we were working back with State Energy Office and other entities that do weatherization programs, whether they're funded by federal government or the Duke Energy programs that we have, the Duke Energy weatherization programs, is that when customers come in and they're qualified for weatherization services, they meet the eligibility guidelines. Then the next step is that an audit is performed on their home to determine what are the opportunities for improvements in their home for energy efficiency. And what we've identified when working back with these external entities is that 40% of the customers who qualify for weatherization services do not receive those services because of health and safety investment. That's usually kind of one of the number one barriers, Chair Mitchell. And so with that right there, that is a direct tie into some of the information that we have in our settlement agreement to put $10 million worth of health and safety investment back into, these are shareholder dollars, but back into where these customers who would potentially end up on a waiting list indefinitely for health and safety investment, they would all be able to receive weatherization services.
Okay, that's, thank you for restating that point. And do you have a way of helping me understand how many customers 40% is?
I don't know what I'll say kind of the denominator number, like the total number right there. I think some of this is based on how many homes that the state weatherization organization does. Just to, I guess, kind of remind the group here is that we work back with 20 agencies across the state of North Carolina to perform our weatherization services that we have. The program approved by this commission in both DEC and more recently, earlier this year for DEP. Those 20 agencies do this work on behalf of not only Duke Energy, but the state weatherization organization. And so whenever these agencies go in and perform the audit, they are then looking and identifying if it's a Duke customer. They have two funding sources, state dollars along with the Duke dollars. And I believe, and we can check on this and follow back up with it, I think the average number of homes is around 2,000 homes a year that are actually get the weatherization services. How many homes are actually on the default list or the waiting list because of some health and safety investment requirement? I'm not sure of that total number.
Okay. And the 2,000 homes that you just referenced, is that DEP service area or is that
right there
statewide?
that is right there is a statewide number, to my understanding, when we've had some preliminary conversations with the state weatherization. That's approximate number. I think it's in the ballpark, but we could, confirm that number.
So that would be DEP customers, DEC customers, muni and co-op customers.
That would be,
Okay.
that is correct.
Okay.
And the unique place I will say around the Duke customers is though that whenever the work is performed in homes for Duke Energy Carolinas and now, like I said, Duke Energy Progress customers, these agencies now have funding through our programs that offset the funding that they can put with the federal dollars that the state is using. And so we believe that as those dollars are fund Duke homes, that allows more other dollars to fund all customers across the state of North Carolina.
All right. Thank you, Ms. Barnes.
You're welcome.
I have a few questions of the panel. I'm glad to see you here today. And I guess want to go over some of what I understand to be the stipulations that are in the settlement agreement. From what I gather, the PIM dealing with income affordability has been withdrawn at this time. Is that correct?
That is correct.
And of course, I think it says the DEC and DEP will jointly contribute $2 million per year for a total of $6 million to the Care the Light Fund. Is that correct?
That's correct.
And then there's this additional $10 million that would be jointly contributed by DEC and DEP that would go toward health and safety prepares that prevent the low-income residents from qualifying for weatherization and energy efficiency, which has been touched upon previously. Now, has there been any thought given to the way those funds, that $10 million, would be distributed in terms of a structure or process, how you identify those that are qualifying recipients or households, what the amount of an award might be, or what, how do you envision that working at this time? Or has thought been given to the mechanics and operations of such a program? And I realize it's at its very early stages right now, but sometimes the devil is in the details. And so I was wondering to what extent had that been contemplated and what you could share with us about how that $10 million would be distributed to qualifying households.
That's a great question, Commissioner McKissick. And we have given some thought. I mean, as you mentioned, the devil is in the details. One thing I will share is the distribution of health and safety funds is not new to Duke Energy. This is something that we've done for Duke Energy Carolinas and Duke Energy Progress through our Helping Home Fund that was shareholder dollars. And with that, in those programs, we work back with the state agencies who are doing the weatherization so that as they are performing weatherization services and they identify an opportunity for health and safety, they have those dollars. They are available so they can install those health and safety upgrades as quickly as possible. What I will share with you is although we have good lessons learned from the Helping Home Fund, we are interested in working with a number of the parties to talk through how we can make sure that those funds are distributed in the most efficient manner and they're making the most impact. One thing that we have talked about is although there's a limit for health and safety fund investment for some of the federal dollars that come to the state, we've talked about potentially not having limits on these dollars. What we don't want to happen is we put a limit on there and that limit eliminates to put someone back on the waiting list. And so that right there, I guess what share is one, I think we have some experience in this. Two, although with that experience, we'll bring that to the conversation, but we're looking forward to working with stakeholders to lay out, including the public staff and others, to lay out a plan on how best to distribute their funds and maximize the benefit for the customers who need them the most.
Is there any preliminary estimate in terms of what the number of households or customers might be able to benefit at this time, or is that unknown?
You know, the reason why it's unknown is because the type of health and safety investment, the cost could range. It could range from, you know, a few $1,000s to multiple $1,000s. And so that is where we think that as we have more conversations with stakeholders along with the agencies that are doing the work, we'll have a better understanding how with partnering these dollars with federal dollars that the state is doing, how we can maximize the benefit of helping as many customers as possible.
And I agree that's going to be the key thing to work out, working with stakeholders and those that might be able to best identify how we can assist the greatest number of those that face affordability issues and challenges in paying their electric bills. And moving into that issue, and I know Chair Mitchell asked about, you know, how many people might be potentially impacted, but in a different context. I mean, from what I gather, if we look at the DEP territory at this time, and we were looking at the proposed customer assistance program, and when I say looking at it, you know, those families or households that would qualify could make up to 200% of the federal poverty guideline, that you're looking at potentially about 29% of households being potentially eligible for that customer assistance program if that criteria alone were used. Does that sound consistent with what your knowledge is relating to the number of households within the DEP territory that, based upon income, not based upon SIP or based upon LIHEAP, could potentially qualify for assistance?
Yeah, what I would say is that the 29% number is a source from the low-income affordability collaborative work stream that we when working with stakeholders for about a year. And during that work product, we analyzed around 2.5 million residential customers' homes. And that 2.5 million was both DEC and DEP collectively. And so when you looked at the results of that analysis shows that collectively between DEC and DEP for those customers that were part of the analysis, you're correct. 29% of those customers on average are below 200% of the federal poverty guideline. And so it was both DEC and DEP collectively.
And as I recall, though, there was actually a higher percentage in DEP than DEC than the 29%, make closer to 32 maybe.
Yeah,
if it was DEP alone.
I'm not sure about the DEP number because I thought most of it was all collectively together.
Okay.
And then when we did do some high level analysis of DEC and DEP, we didn't see material differences. That's why we did most of the analysis, you know, as a system between both DEC and DEP in North Carolina.
And I believe that there was some study done using zip codes. Is that correct? During the low income collaborative work.
Yeah, so what I would say is, I don't know that we did a study. What happened was, as we were looking at analyzing information around demographics and characteristics of our customers, we had a number of low-income collaborative members who requested to have the information presented by zip code. And due to the company's code of conduct, what we did is in January of 2022, we filed a request with this commission of a limited waiver to share data with collaborative members based on their request. So there wasn't a separate study done, but it was, hey, can you take the information that you've already done and get it down to a zip code level? And we filed that request with the commission. This commission issued the order, I think, in March of 2022, which was a very limited scope order that allowed us to share the information with a limited set of collaborative members with the requirement that they would return it back, at the end of the collaborative timeframe.
Yeah. And that was my understanding, the way it functioned in terms of the analysis, the low income affordability collaborative, how they use the zip code. But one thing which I saw in reviewing some of the data, it said if you look at households with very low incomes, when they defined that, they were talking about $15,000 or less in terms of annual income. There were nearly 227,000 households in the DEP service territory, or about 10.6%. And I mean, those are people who are really making very little money per year and struggling to pay their power bills every month. And I guess what I'm interested in knowing is that, assuming we were to move forward as a commission with this customer assistance program, how are we going to really help some of those people that are in what I refer to as deep poverty? And I believe that's typically used as a term of art to really make certain that we're able to improve their financial burden. Because I know I listened to what I call testimony that came in some of these public hearings. And if you go down there to someplace like Robeson County, and you listen to those people who make $7.50 an hour, some of them make $15 an hour. People might say it's a livable wage, but I'm not so sure it is today. And you hear about them paying $300, $400, $500 a month for their power bills. It's a substantial burden. Now, granted, they may be living in housing stock that's 50, 60, 70 years old, or they may be living in mobile homes that have very limited insulation, perhaps not even a foundation or skirting. Granted, they are living in accommodations that leak energy, and weatherization can help. This proposed bill credit, that's a flat bill credit of about $40 to $42 a month. While it may help, they're in need of significant help. And what are your thoughts about how this program might actually be implemented? I mean, what are your thoughts about what's going to be done to help those in deep poverty? And more importantly, how you might structure it in the future moving forward. I understand that the settlement agreement allows for evaluation of some type of tiered program in the future, but perhaps you can speak to that before I go any further.
So I might start and then invite others to add on. First, I just want to acknowledge the real challenge and the real importance of your question. Customers, as you mentioned, in deep, who are really struggling to pay their bill is a real serious problem that we discussed at length in the Low Income and Affordability Collaborative. And it was really important for us to discuss the best ways we can take the most significant step forward right now and build a foundation to continue to do. We know we're not going to, these are really serious societal challenges, and we want to be part of helping our customers as best we can, given the constraints that we have. And I think the conversations in the Low Income and Affordability Collaborative were really constructive. I'm really proud of the settlement and the proposals that we came forward. And I think you heard from some of the other witnesses as well that we feel that this is a significant step, and we're looking forward to the conversations about tiering and about how to improve it in the future to help as many customers as best we possibly can.
And I appreciate your thoughts on that. I mean, the thing that gives me concern is that the customer assistance program, as it's presently proposed and structured, the only people eligible will be those that are part of a LIHEAP program or the SIP program. And if you compare that to the universe of people that fall underneath that 200% of the federal poverty guideline within DEP's service area or territory, they're only 2%, as opposed to perhaps 29% or in that range that would theoretically qualify for a customer assistance program. Are there any thoughts you can share with me about how you can go beyond that 2% that are LIHEAP or SIP qualified to be able to reduce their affordability burden as well when it comes to their monthly bills for electricity? Not all utilities, just electricity.
So just for the record, our estimates are that it would be 4.7% of DEP North Carolina customers.
Okay.
The 2% came from the study in the Low Income and Affordability Collaborative, where we needed to sort out some customers for data quality issues, or there was some interruption of service. So I just want to be clear on that. I think some of the things mentioned by witnesses Howitt and Colton were some ideas of how to possibly expand the program in the future, that other programs that could qualify customers for CAP. At this point, I think it's really important to take this first significant step, continue the conversation about tiering and continue the conversation. So I think this is a really important step that can help a lot of households. And we can kind of move forward from there.
And when you say 4.6% that you're talking about those that are LIHEAP and SIP qualified, is that correct?
That's correct.
All right, as opposed to, say, the 29% in the territory or so that are theoretically might be eligible.
The 29% that are estimated to be below 200%.
Exactly.
Yes.
And the 200% is what's used as a threshold in the customer assistance program.
The customer assistance program sets the eligibility for LEAP and SIP.
Okay.
The program itself doesn't take a stance on a low income threshold writ large.
Okay. Let me ask you this. In terms of the reports that will come in, and it hasn't been stated what the frequency of reports might be. What are you envisioning could occur, assuming this were to move forward? Because I think getting good information and data would be critical in terms of assessing the effectiveness of the program as currently proposed. And likewise, well, let me ask that question first before making it a compound question.
So I want to add again, we have general success metrics that we've discussed in LIAC. I think in terms of our proposal, we knew at a high level that we wanted to move forward with those success metrics as agreed. Given some of the uncertainty in the proposal, we don't have a fully laid out plan, but we plan to work with the stakeholders and file regular reports with a lot of the statistics that Commissioner Hughes mentioned. So I don't have a fully laid out plan. It's more of we know these are success metrics. We know what we're trying to do at a high level, and we want to report on that as best we can.
Do you think every 6 months would be a reasonable frequency?
Yes, I think at a general level, yeah, I think that is reasonable.
And do you believe that if information and data is coming forth, that it might be opportunities to suggest potential revisions to the pilot before waiting for it to expire in 3 years?
Yes, in general, I think that's reasonable. I would want to make sure we give it some time to see what happens and to address any challenges that come up. But absolutely, if we think that there's a better way to do things that we have confidence in before the conclusion of the 3 years, I think that'd be a reasonable thing to discuss.
And as I recall, in your rebuttal testimony, what was suggested is that this actually be a 4-year program as opposed to a 3-year program because of the frequency that one might come in for rate cases. Is that correct?
So we, originally in my rebuttal, we suggested a 4-year with the idea that so it'd be 3 years of operations, and then there may be some time for discussion. We didn't want to let the program lapse while the commission or different parties were discussing. In the course of the settlement, we agreed to do just a 3-year pilot to align with the public staff.
If you determined during the course of this pilot that there was a valid, rational basis for extending it beyond 3 years to make sure there was not a lapse of coverage, or not necessarily coverage, but of benefits to eligible recipients, is that something that you feel that you could come back and petition for? Because otherwise, if it expires in 3 years, you have people that might be receiving benefits, and they could be put into a situation where they're having even more dire financial hardship.
Absolutely. The only caveat I would give is I would want to have forthright discussions with other parties, including the public staff. But absolutely, that's something that we might want to consider.
And I guess another question that comes to mind, if you have somebody that is SIP or LIHEAP qualified, and they become a part of the program, and it's going to be automatic for them. I mean, there's no application process. What if some point in time they might become ineligible for SIP or LIHEAP? How would that be handled during the course of the 3-year pilot, if you have any ideas about that at this time?
Yeah, so when a customer receives LEAP or SIP, they become eligible, and we'll get that list from DHHS, and we will enroll them for 12 bills. So they're enrolled in CAP, and they're going to get a bill discount for 12 bills, and that gives them a degree of certainty. If at some point they are no longer eligible, after the 12 bills, they wouldn't be on the subsequent lists that would sort of remake them eligible or re-enroll them in the program. And so after 12 bills, they would roll off the
It
program.
would roll off. It
And
would
if-
not be an automatic. Were you about to say something?
Well, I just want to add too, I mean, we would be sure that we communicated to those customers, and, we don't want, the last thing we want to happen to these customers is all of a sudden this $42 credit disappears from their bills. So we would be very intentional around communicating to the customers why, or if they need to get recertified with the state or whatnot before they actually get removed from the program. So I just want to add that to Mr. Harris's comment also.
Add it in all.
If I could also just take the opportunity to kind of say that the auto enrollment feature is something that we were really excited about, because all of our customers value their time, especially we think a lot of low-income customers. There's a lot of life is complicated, and there's a lot of programs that can potentially help people, but having to fill out another form, go through another process is a burden. And so one of the things we're really excited about this project, this proposed pilot, is the idea of making this really easy for customers. They don't have to apply for anything additional. They just get a lower bill, and they can focus on the rest of their life.
And I guess that brings another question to mind. As you're aware, the application period for LIHEAP and SIP are pretty narrow windows. You recall exactly what they are?
I don't. I believe it's in one of my
is.
exhibits. I believe the SIP, the Crisis Intervention Program, is eligible year-round. I believe LEAP is does have a season. Yeah.
Start
a
around
few
the
months.
1st of December or something there, somewhere thereabout. Remember, Ms. Barnes?
Yes, LIHEAP is for winter months, so it's December through March. When
Mhm.
customers are eligible to pay for, apply for LIHEAP, because that assistance is really around heating. And then as Witness Harris mentioned, the SIP assistance is available year long, so customers can apply for that throughout the year.
But there's a limited amount of money that's available for both programs.
That is correct. What I would share is that from my understanding, of course, because these are dollars that are federal dollars that come to the state of North Carolina, and at the state of North Carolina Department of Health and Human Services administers these dollars, there is a limited amount of money that comes in the budget for this assistance. As Witness Quick mentioned earlier, especially during COVID, there was an influx of dollars, more so than most of these agencies had ever seen. And one of the things that you touched on earlier was around how we are, or how this program, and we can make sure that for those customers, if we describe them as in deep poverty, that are having most of the most significant financial challenges. I think there are a couple of things I'd like to just leave this commission with, and is that from a Duke standpoint, we have identified a number of ways that we can partner with these agencies. Some of them is at the state level. I mentioned the state energy office around weatherization, where we're having some conversations, because they are too similar going to get an influx, I think around $90 million for weatherization over the next 5 years from federal dollars. So how can we partner with them with our program to make sure that we're impacting more customers? I think the other thing that I would share is around Department of Health and Human Services. We've had a lot of conversations around CAP, and how can we make sure that we can partner with them to educate customers? Because some of the things that Ms. Witness Quick shared earlier, a number of customers who qualify for these services or these dollars don't even know that the dollars are available. And I know that Witness Quick, your team has done some work with Mecklenburg County just to really connect dollars, so that at the end of LIHEAP, my understanding is if an agency doesn't spend all the dollars to help customers pay their bills, those dollars have to be returned. And so what ends up happening is we've been able to build a partnership, I know with Mecklenburg County, that we're looking to build upon, and turn over maybe if you could share more about that.
Yeah, I think you're referring to the payment navigator proposal that I have in front of the commission also. So we know these customers call us, on a regular basis, and maybe monthly, maybe a couple times a month. And so with our payment navigator proposal, we're really trying to help customers so that they don't have to continue to call us each month. And so it's really looking at our affordability ecosystem, which is the energy efficiency programs, weatherization programs, the bill assistance programs, whether it's the installment plans, et cetera. Really trying to look at it holistically from a customer's perspective to see how we can help them, not only in the short term, but also in the longer term. And another thing we know, just, you kind of reminded me of this also, but, some of these customers have difficulty even reading and filling out the applications. What we realized during our payment navigator pilot is that many customers were dropping out at some point during the application process. So we would see them get connected to the agencies. We would see them drop out of the application process at some point. So if we can have these payment navigator specialists sit down with the customer on the phone or whatnot, not literally sit down, and then really help them through these situations and maybe where they are dropping or stopping from completing the application. I mean, that's where we think these payment navigators can really benefit our customers, especially these customers who are part of the customer assistance program or whatnot that really need additional help.
Well, I would concur that you got to meet people where they are.
Yeah.
And if there are issues related to literacy, if there are issues related to language, because someone may not speak English fluently or understand what's being requested, or perhaps they don't even have internet connectivity. There needs to be means for reaching out to that entire universe of potential people that this program could serve. And of course, what I've read about more than funds getting returned is funds running out, so that there are people who are qualified that aren't eligible to join either SIP or LIHEAP because funds end up getting exhausted at some point. So I guess my concern is that I want to know if this moves forward, that there's going to be vigorous effort made to reach not just the LIHEAP and the SIP eligible persons, but, under the low income affordability collaborative, that 200% of federal poverty guideline is something that we're striving to obtain and trying to do it in a vigorous way. I see some heads nodding, but can you comment for the record on that?
Yes, I will comment and say this. The work with the LIHEAP and SIP is a starting place. We never said it was the final. And so I think you make a great point of these customers between 150 to 200 that don't qualify. As part of the settlement agreement, one of the things that we talked about is working with stakeholders on a number of aspects related to CAP. And I think these are conversations that we can continue, Commissioner McKissick, in those conversations. And I think as we look at the value of CAP is streamlining auto enrollment, keeping administrative costs down. If there are other opportunities that we can see that there may be customers who are above the 150 to 200 may be able to enroll, I think that's something that we're open to talking about with stakeholders and bringing back before this group if we need to at that time to address that gap that you've mentioned here.
Yeah, I think reaching the maximum extent feasible that would fall underneath that 200% of federal poverty guideline would be the aspirational goal and target. And it's consistent with the low income affordability recommendations. And let me just ask you one or two things about, I guess, that what's been known as kind of proposal number 24 that's come up consistently in testimony provided by witnesses on behalf of some of the interveners. There were a lot more things placed in there, about a tiered structure. And I take it you interested in working on a tiered structure and committed to doing so. Is that correct?
Yes.
Can I jump in real quick? And I'll let you talk about the program. One thing I'd like to just make sure that this group knows how we came up to proposal 24.
That
So-
would be excellent.
So-
If you could put that on the record, because I've heard from others, and I think it's only fair for you to share your thoughts.
Thank you. So during the Low Income Affordability Collaborative, we had months, of course, as this commission know, of meeting with collaborative members where I would describe it as an opportunity for an exercise where we all were able to listen and learn. And after several months, any collaborative member had the opportunity to submit a program proposal. We actually had 22 program proposals that were submitted. And then after looking at 22, there were 4 proposals that were very similar. Okay. As it relates to proposal 24, that was proposal 9 and proposal 22. I think proposal 9 was submitted by the North Carolina Justice Center along with a few other stakeholders. And then proposal 22 was submitted by the company. And in an effort to not require low-income collaborative members to assess very similar proposals, our third party at the Administrator Tom Godhouse proposed for similar proposals, would collaborative members who submitted those proposals be willing to combine the proposals? That way, it would allow collaborative members to assess very similar proposals at one time. And so the North Carolina Justice Center and parties, along with Duke Energy, agreed that proposal number 9 and 22 could be combined. And that is how proposal 24, I would say, was birthed. Okay. When you look at proposal 9 and 22, though, they're not exactly the same. They are similar in nature. And so I just share that because I know that witness Harris will share kind of some of the components that are different. But I wanted to give that background on those are actually 2 proposals that were combined versus 1 proposal that was submitted just as written.
Thank you for providing that insight. It's appreciated. Now, among the things in proposal number 24 was looking at what I would refer to as the energy burden that's on families in terms of how much of their income should go toward electricity, utility, so to speak. And there was a recommendation that that percentage be 5%. Is that something that Duke supported? It was my understanding that Duke supported, proposal number 24, and that was part of it.
So in the context of proposal 24, that came up as a general target for the program. It's something that we have to weigh against all the other challenges and success metrics. How much the program will cost, can we do tiering, the operational constraints, how many participants we have. So it is something that I think we viewed as a goal to get that electric energy burden below that level. But it was not a firm commitment that this will always definitely happen.
And I think the other thing that I'll just share is around the 5% or whatever the number is around energy burden. You know, if there's an energy burden number, we talked about this with in the Low Income Affordability Collaborative. There are states or jurisdictions that have truly, hey, this is our energy burden target. On average, we want the energy burden. I think in New York, for example, they want the energy burden target is less than 6% for low income customers. Most of those places where we looked at through LIC, it is whether it be statutorily or commission ordered, and it is across the board for all the, I'll say, utilities that, you know, meet the requirement. And to do that, you have to understand what is the income, because the energy burden is a certain percentage of this customer's income. And so with that right there is, I think too, it following up on what Witness Harris shared is, we don't have income information for our customers. With all due respect, I think that when we think about what we require them to provide us to provide the service that we have electricity, we don't need to ask them for income burden. And I can only imagine how if our call center reps were asking for income burden, how that would be received. I mean, income information, how that would be received. So while I do think that in general, to your point, that is in Proposal 24, I think it started with Proposal 9 that our partners with the North Carolina Justice Center and others put in their original proposal. What I would say is we don't really have the information at that level to track energy burden from based on the information we have from our customers. And so with that right there, I think kind of generally what we talked about in Low Income Affordability Collaborative, if this commission deems that we do want to have an energy burden target, you know, I think similar to potentially what other states have done or other commissions have done, I think there's an opportunity potentially maybe, and I think we put this in a Low Income Collaborative report of potentially opening up an affordability docket. And I think that that way other utilities across the state that this commission has oversight over, we could look at it from a state specific view versus maybe a program view that may be very limited in scope and limited in the customers that you're going to provide that value.
And that brings me to another question that was in the back of my mind a while back. And that is in the meetings that are going to be held moving forward with the stakeholders. It's my understanding that in the past, one of the stakeholders has been, and I would assume would be a part of this group moving forward, is North Carolina Department of Health and Human Services. And of course, it's involved with LIHEAP, SIP, all these type of programs. And they apparently do have income data that they receive related to recipients and trying to make that income data available. Now, is that part of what you might be doing moving forward to try to get to a point of having the income data that you need to be able to implement some type of affordability target?
So with regards to the CAP program, what we have discussed with various parties in terms of the tiering is just when customers apply for LEAP or SIP, their income needs to be verified for those programs. Can instead of it just being a yes or no, they qualify, they don't, can they be categorized into the different, for lack of a better term, tiers or buckets?
The 3 tiers.
Yeah, and then that be communicated up so we can administer a tiered discount. So that's the level of data sharing on income that that has been kind of proposed in this process.
Do you think that's viable and feasible to move forward with? I mean, and when I say move forward with, to hopefully get Health and Human Services on board to share that kind of information, or do you see it being problematic in some respect? I mean, obviously there are other jurisdictions where, as Ms. Barnes indicated, they set targets in that 5-6% range is not uncommon. So what are your thoughts about what we should be able to obtain here in North Carolina?
I really can't speak to DHHS. I know that we've had some conversations about this with them, but I don't think I have the information to kind of speak about what they can or can't do.
I'll be
Ms.
glad.
Barnes, yes.
Yeah, I'll be glad. Yes, sir. I'll be glad to elaborate on Commissioner McKissick. One thing I would say is that DSJS has really expressed their interest in partnering and working with us. They were actively involved in the North Carolina, the Low Income Affordability Collaborative. Similar, I would kind of describe it to Duke Energy, though. Their clients are coming to them for a specific purpose, to get financial assistance potentially for LIHEAP and SIP, bill pay assistance. They give them that information for that purpose. Just like when customers come to us, they give us their information to provide, for us to provide electric service to them. And although we went into 2 data share agreements, the first data share agreement we went in, and Witness Quick mentioned this earlier around COVID to expand the moratorium to LIHEAP and SIP customers, it required a legal data sharing agreement for them to give us data. Then we went in a second data share agreement with them for the Low Income Affordability Collaborative to include those customers that were participants in the winter moratorium to in the research analysis. They do not have the liberty just to say, hey, let me just send this data over to Duke Energy, even though they're committed to working with us from an affordability standpoint. They have statutory requirements on when and on what instances they can share data. And I only share that, Commissioner McKissick, because I don't want to leave this commission with they're not interested in doing it. They too, like Duke Energy, are working within the guidelines and the restrictions that they have set forth in there from that standpoint. So I don't know. In conversations with them, we've never said, hey, can you give me this customer's income data? What we've shared is how can we partner together to address affordability, knowing that some of the very customers who would need this assistance are coming to you first. And so with that right there, can we get to the point that maybe the tiering piece can be done? That may be something that, yes, we could do. Will we get to the point that, hey, they're going to give us each customer's income data? I think that right there would be a huge hurdle to overcome based on what we have, the current limitations of what we worked through at this point in time.
So from what I hear you stating, you believe that you could probably get the information from them that would satisfy the tiers, but perhaps not discrete income data as it relates to each individual recipient.
Yeah, what I would say is we've had conversations with them about tiering. Even in response to Proposal 24, they actually provided comments in the Low Income Collaborative, the final report that detailed why they couldn't do tiering and how their system doesn't capture it. So I feel like that the door has already been opened. They welcomed additional conversations around potentially tiering. And so for that reason, I do believe that that is something that we will continue to have conversations with as we committed. And that's something that is probably maybe more feasible than the individual income data for, each household that applies for LIHEAP or SIP assistance.
Sure, and because I mean, it looks like the tiers that were contemplated with the Low Income Affordability Collaborative included from 0 to 50% of the federal poverty guideline, and then a second tier from 51% to 100% of the federal poverty guideline, and then tier 3 being 101% to 150%. I certainly hope that you all can work together collaboratively if this moves forward to work with Department of Health, Human Services to get that information, because I think it would help substantially to get to some type of program that can take in consideration tiering and how you might assist those that have the greatest need first, to be honest with you. Another thing that came up with Affordability Collaborative was a program that would allow for what I call arrearage forgiveness if somebody enrolled in a program and they made payments for 12 months. In that 12-month, at the end of that 12-month period, looking at arrearage that was left and implementing some type of forgiveness program. Is there a reason that wasn't included as a part of the proposal that came in with the application where the customer assistance program was proposed?
Yes, arrearage forgiveness like that is just a little bit more complicated, both from a administrative point of view and a policy point of view. And so we thought that it, as a good first step, considering that we had the time between the Low Income Collaborative and preparing for this proceeding was limited. We thought it was a good step to move forward with what we knew we could execute in a fairly rapid manner, and we felt like we could execute very well on. And we do believe that the customer assistance program will help customers stay current on their bills. So it should have some sort of effect on arrears. And so we thought at this point, we would move forward and take this really important step. And that's something that we are open to further discussing.
Well, I think further discussion would be warranted, and particularly since there are jurisdictions where they do have arrears forgiveness type programs, as well as the affordability type programs targeted to 1% of income. I think I've probably covered most of the things that were in the back of my mind, even though I have not gone by my notes. So I appreciate the concept of what's proposed. I think that the details are going to really impact the potential merit of this program, coming up with the metrics for evaluating effectiveness, whether it's the reduced number of disconnections, whether it's the level of participation from eligible households. And as you've heard me say, I'm very concerned about those that are not necessarily a part of the SIP or LIHEAP programs that would theoretically be within 200% of the federal poverty guideline, also having an opportunity to receive benefits. And so, I mean, I think there's a lot of work that's yet to be done. I hope there will be 6-month reports. I hope that you will potentially look at continuing the program before it ends at 3 years, where people that might be impacted are left there without assistance. So, I mean, I think there's a lot to be worked upon. And I hope that if this moves forward, that'll be valuable information that comes from the stakeholder process. The thing I don't want to see is this report that comes in at the end of 3 years that falls short of assisting this commission to evaluate how we can assist those people that really need help the most. Because nowadays, 200% of federal poverty guidelines still is not a lot of money if you're looking at a household of 4 or 5 people. You know, it falls far short of what perhaps we have the capacity to do as a commission and as a state in addressing this need. And I think if you ask most people what we should be doing in terms of evaluating the impact of proposed increase in rates, they would say the key thing is affordability. Where does it fall? And if you look down there and you see at the end of year 3, it's $25, $30 a month, and these people are already burdened, that's substantial. If you look at the impact that's added to that from things like fuel, and you know, we have the fuel rider that's going to be impacting it, as well as other cost expenses, is substantial. So, I mean, I hope that you all will thoroughly flesh out these details and report back to us in detail where we stand if this program moves forward. Thank you.
Do you have a question, Commissioner Clancy?
Ms. Barnes, I want to do one follow-on to a discussion you had with Commissioner McKissick in response to one of his questions. And you refer to the fact that there are a number of states, I don't know how many, but there are states that do have articulated an explicit goal or target for energy burden. In those states, and I'm just interested in examples, who collects, compiles, tracks, and monitors income data for the customers in order to determine where you are in terms of that target?
Most of them that we were identified have been state agencies.
Such as DHHS.
Such as the DHHS, and they're doing this maybe in what I would call the normal course of how they do business versus some other entity, unless there's some type of like universal service program that is collecting dollars from different multiple sources, but that usually still is some type of state entity that's doing it and not necessarily the utility.
Is information about those other states buried somewhere in one of the footnotes or one of the schedules?
You know us very well, yes. So in the Low Income Affordability Collaborative Report, there are a number of footnotes around some of the programs where, or states or jurisdictions. And so, but we could make it easy and pull that forward.
I'll save you some time. You just have your counsel send an email as to which footnote I should go back and read. I've read the text, but it's a very dense document. So
That's a nice way of putting it. Yes, we'll make sure we get that over to
thank you. I appreciate it.
All right, questions on commissioners' questions? Go ahead, Ms. Kress.
Thank you, Chair Mitchell. Good afternoon, Mr. Harris. I want to follow up on a discussion you were having with Commissioner McKissick regarding metrics and reporting frequency. Is the company planning to report how, if at all, the CAP program recipients' consumption changes while they are receiving CAP program benefits?
It's something that has not been discussed. It is something that could be measured. I will mention that changes in usage, particularly by these customers, I think there's in rate design and rate making, we often worry about energy efficiency and encouraging in rate making not wasteful usage. I think particularly with this customer group, an increase in usage wouldn't necessarily be wasteful. I think customers not being sweltering hot in the summer, and having the ability to turn their thermostat down and be more comfortable, some situations more safe, wouldn't necessarily be a wasteful energy. I think that would be quite good use of energy.
So back to the question, is the company planning to report how, if at all, the CAP program recipients' consumption changes while they are receiving CAP program benefits?
So it's something that could be measured. It's not something that we have committed to at this point in time.
So is that a no for the record?
It's something that we have not committed to at this point in time.
Chair Mitchell, if you could please instruct the witness to answer the question. It's a very simple yes or no question.
Chair Mitchell, I believe that witness Harris has answered the question twice on the record.
All right, and I'll overrule the objection.
So no, we're not committing to do that.
Thank you. Ms. Barnes, you had a discussion with Commissioner McKissick about the proposals that were brought forward by the LIAC stakeholders. Is that correct?
Yes, that's correct.
If you could please turn with me to SIGFOR 2 potential cross exhibit number 57. And that has been previously entered into the record as SIGFOR 2 cross examination Harris Direct exhibit number 1. Is it 27?
Ms. Kress, what is the number of the potential exhibit?
57.
Okay.
I'm sorry, could you repeat the page number again?
It is, so it's potential exhibit number 57.
I'm there.
If you could turn with me to page 70.
I'm there.
And so, Ms. Barnes, if you could speak to whether there were proposals brought forward by certain LIAC stakeholders that would not have created a new interclass cross-subsidy?
Chair Mitchell, I would object. I don't recall any commissioner question that was focused on whether a proposal addressed cross-subsidy or subsidy issues at all.
And Chair Mitchell, I'd just respectfully respond by saying that there were a number of questions asked and a lot of discussion happened between Ms. Barnes and Commissioner McKissick regarding the proposals and the process by which proposals were brought forward in the LIAC collaborative.
I don't recall Commissioner McKissick's questions going to interclass subsidy, so I'm going to sustain the objection.
Right. Ms. Barnes, would you agree that there were a number of different stakeholders who brought forward proposals during the LIAC collaborative?
Yes, I agree.
And just for the record, there's only one proposal that is being recommended by the company in this rate case. Is that right?
That is correct. There's only one being recommended in this rate case. There have been other proposals that were recommended that have been already filed and approved. But there's the one from the collaborative that's in this rate case.
Thank you.
Go ahead.
Briefly, David Neal, NCJC et al. There was in response to Commissioner McKissick's questions about arrearage management, could you just clarify for me that part of the settlement includes $6 million contribution from Duke, the Share the Light Fund, isn't that right?
That is correct.
And is it true that the Share the Light Fund itself can help eligible customers with past due balances?
The Share the Light Fund, yes, can help customers with past due balances.
Thank you. That's all I have.
No questions.
All right, company.
I just have a few.
Okay.
I'll first address this question to Ms. Barnes and to Ms. Quick. In answering questions from Commissioner McKissick, we were talking about the programs and services, and specifically addressing the LIC for helping the most vulnerable customers. Can you talk about how the CAP proposal in this case interacts with the company's existing programs and services?
I'll be glad to. I think one of the things I would just share is that as customers are qualified for CAP and they have bill pay assistance, these customers also could get bill pay assistance from other sources from that standpoint. I think the other thing I'd highlight is, as we talked about earlier today too, is the opportunity, because we know these customers meet the income qualifications for our weatherization programs and energy efficiency programs. This is an opportunity that we would then also integrate, or what I would say, refer them to weatherization services. As Ms. Kress mentioned, although CAP is the only request from the LIC that is in this docket, I think it's really worth us talking and sharing about how we as a company, and Ms. Quick mentioned it, we talk about the affordability as an ecosystem. There are a number of tools that the company has in this toolkit when it talks about bill pay assistance, energy efficiency and weatherization, and then also the payment navigator to help show up with these customers to provide them information that not only can help inform them of where resources are, but actually connect them to resources. And so I think, Mr. Combs, that right there is kind of how we're pulling it all together. I think it gets a little bit challenging. One of the values that we have with the Low Income Affordability Collaborative is, whether it was bill pay assistance, energy efficiency, payment navigator, we're able to talk about the ecosystem in totality. Here in some of these proceedings like today, there's a specific scope. And so we're talking about bill pay assistance, but that is not the only thing that the company is, focusing on to help address affordability as we pull all of these tools together to assist customers.
Yeah, and the only thing I'll add there too, if we can keep these customers out of the credit and collection cycle, it's really beneficial to all customers, because these customers really cost us more because they're getting more notices. They're calling us more times. Their bad debt could potentially be higher or whatnot. And so through the payment navigator efforts and the CAP program and the EE programs and weatherization programs, we really can lower the costs to serve all customers by keeping these customers out of that credit and collection cycle.
And I just one last question. I think, Mr. Harris, you talked with Commissioner Hughes and Commissioner McKissick about metrics and reporting. Can you just talk about how the settlement agreement, the stipulation that was reached, addresses the metrics and reporting for the CAP proposal? And if you, I don't know if you have a copy of the settlement up there. I'm referring to page 5 of the settlement agreement. And it's number 5, subpart B on that page.
I think. Apologies. Says the stakeholder group will consider data collection and reporting issues that will be necessary for CAP. The stakeholder group will consider metrics and inputs used to assess the CAP pilot program, as well as any adjustments that will be needed to assess any changes to the CAP program. And the companies agree to update the commission on the stakeholder engagement processes regularly.
And so the issue of like, how the reporting will take place, and I guess the frequency is still going to be discussed and decided upon by the stakeholders.
Yes, that's correct.
Okay. No further questions.
All right, at this point, we have come to the end of this panel's testimony before us. We will take, I will take motions from council.
I think I already
If there
moved.
are any.
Yeah, I think there are no motions. I
Okay.
didn't have the exhibits.
All right, with that, you all may step down and be excused. Thank you very much for your participation in this case. All right, Duke, you may call your next witness.
Thank you, Chair Mitchell. At this time, DEP calls the witness stand Mr. Carl Newland on rebuttal.
All right, Mr. Newland, I'll just remind you that you remain under oath.
Yes, understood.
Welcome back, Mr. Newland.
Thank you.
Although you've previously testified, could you just please state your full name and business address for the record?
Carl W. Newland, 525 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
Duke Energy. I'm Senior Vice President of Corporate Development and the Treasurer of the company.
Mr. Newland, on April 14th, 2023, did you pre-file or cause to be pre-filed in this docket rebuttal testimony consisting of 37 pages as well as 6 exhibits?
Yes, I did.
Were these exhibits prepared under your supervision and direction?
Yes.
And are these exhibits true and correct to the best of your knowledge?
Yes.
Are there any corrections you need to make to your pre-filed rebuttal testimony?
No, not that I'm aware of.
And if I were to ask you the same questions today under oath, would your answers be the same as those set forth in the pre-filed rebuttal testimony?
Yes.
Chair Mitchell, I move that Mr. Newland's pre-filed rebuttal testimony in this docket be copied into the record as if given orally from the stand, and the exhibits previously described be marked for identification as pre-marked.
All right, the rebuttal testimony of DEP witness Carl Newland filed in this docket on April 14th, 2023, consisting of 37 pages, will be copied into the record as if given orally from the stand. The 6 exhibits to that testimony will be marked for identification as they were when pre-filed.
Mr. Newland, did you prepare or cause to be prepared a summary of your rebuttal testimony that was pre-filed, I believe, on May 9th, 2023?
Yes, I did.
Chair Mitchell, the summary was pre-filed on that date, provided to the commission and all parties in accordance with the commission's instruction. And I ask that it also be included in the record as if given orally from the stand.
All right, the summary of the witness testimony will be copied into the record as if given orally from the stand.
And Chair Mitchell, the witness is available for cross-examination and any questions from the commission.
All right, we'll start with Sigfer.
No questions.
All right, CUCA.
No questions from CUCA.
Okay, NCJC.
Also, no questions from MCJC.
All right, my notes indicate no questions from the public staff. Is that correct?
No question.
Okay, all right, we will go to questions from commissioners. Let me start with Commissioner Brown Bland. All right, Commissioner Clodfelter. Commissioner Duffley. Okay, go ahead.
Good afternoon. Turning to your rebuttal testimony. Let's see, page 4, line 11.
Yes.
That lines 11 through 14 read, the company's requested The company's requested 53% equity ratio and 10.4 ROE strikes the appropriate balance in keeping rates affordable for debt customers while allowing for necessary levels of leverage and cash flows to maintain DEP's current credit rating. Is it your understanding that the company's request on the equity ratio and the ROE remains at 53% equity and 10.4 ROE?
Yes, it's my understanding that it stays the same.
Okay, thank you.
All right, Commissioner McKissick, Kimmerite. All right, Mr. Newland, I have a few for you. Your rebuttal testimony discusses the importance of considering the company's cap structure over a period of time instead of using a single point in measurement.
Yes.
Do you agree with that
Yes.
statement? Okay. Can you provide the average equity layer for DEP since the last rate case?
I don't have it off the top of my head, but we may have had that in an exhibit.
Okay.
I mean, our approved was 52%, and so it would tend to vacillate around 52% just from quarter to quarter equity.
All right. All right. I'm curious about sort of flexibility and timing, debt issuance. So beyond the notion of a spread advantage relative relative to issuers with lower ratings, do you have any ability to quantify the value to the company of flexibility in timing debt issuance that might not be available to the company if it were downgraded by one notch?
Sure. So, so a company with higher ratings would have a spread differential. So the better credit quality, the lower the credit spread over the treasury. So just so we're all level set. So when DEP or any utility out of the Duke complex needs to issue debt securities, it's priced as a underlying treasury first. Let's say it's a 10-year bond, it's a 10-year treasury, it's kind of a benchmark. That's considered a risk-free rate. We can't issue at the risk-free rate. And then there's a credit spread that's put on top of it. That credit spread is determined by investors looking at the credit ratings of the company and various other kind of inputs. And so, you know, over time, that spread will vary depending on macroeconomic environment, et cetera. And in the last, I'd say in the last 12 to 15 months, we've seen a widening of the credit spread as the market digests, you know, several external events, as well as just activities within the company and comments from the rating agencies. And so we've seen that spread, just to kind of put it in perspective, you know, for a 30-year security, we've seen that spread kind of go from 110 basis points to kind of 140 basis points, just to give you a sense of how that's kind of, you know, moved over time. I think directly to the question you're asking is about access, you know, during periods of dislocation. We've definitely, you know, seen that. And so in some of my exhibits, we talk about no issue days. And so no issue days are when there's events that happen and no one comes out in the capital markets and issues, regardless of sector. So most recent example of that was the week when Silicon Valley Bank collapsed, Credit Suisse was sold to UBS. We were actually teed up with two other issuers within the Duke complex to come out, and the market was very unsettled, and we were unable to, or we decided not to issue into that market. You can always go out into the market, but the bankers will tell you that if you do so, that kind of 130 basis point spread I was talking about could easily become 250 basis points. You definitely don't want to go out and issue a security during that time frame and have that marker, that precedent set out there by doing so. So you hold back. You don't issue. And everyone across the sector did the same thing. They stood down, and that went on for it went on for a whole week. And just within the overall Duke complex, you know, we fund overnight and short term with the commercial paper. And we were building up a commercial paper balance because we had a need to issue securities from these two subsidiaries. And we were rolling $1 billion, $1.1 billion, $1.2 billion kind of overnight. And so it was definitely an impetus for us to issue the securities and to to get along our way and pay down the short-term debt balance. So finally, the following Monday, we came out with our Duke Energy Ohio issuance, and we followed the next day with Duke Energy Indiana. And we were the first ones out. We led the market. We reopened the market that day. And only utility with good, strong credit quality is able to do that. And we were able to do it successfully and move on and pay down the commercial paper balance. You know, there's an example that's very similar from the COVID dislocation during that March of 2020, but it's really the same type of story. The ones that reopen markets are typically insurance companies and utilities, and the Duke family of companies is strong to be able to do that.
All right. Can you think of any issuances by utility companies other than Duke that weren't able to move as quickly as Duke was able to? So we're because of credit ratings?
Yeah, I definitely remember during the COVID crisis, there was actually a utility, may have been a holding company, but there was definitely a utility that had to pull an offering because they couldn't get the pricing interest that they expected.
Do you remember what utility that was?
It was an Entergy company. ETR is a ticker. I just don't remember if it's a holding company or one of their subsidiary companies.
And was it in 2020?
I believe so.
Okay. All right. On page 34 of your testimony, rebuttal testimony, you list authorized ROEs for 9 companies that you consider to be DEP's peers. I'll give you a second to get there.
Page 35.
30.
Table 4.
Let's see. I have, yeah, you're right. You were right at page 34. Table 4. Is that what you're looking at? Page
I am,
34, table
yes,
4.
table
Okay,
4.
making sure we're on the same place. Okay. So it's our understanding that the Florida peers have a mechanism that increases the ROE in response to changes in interest rates. Is that your understanding as well?
That's correct. Especially our subsidiary I'm the most familiar with, but we have a mechanism there that once the 30-year treasury had moved, I forget, a certain amount of basis points within a certain amount of time, then the ROE was allowed to be increased by a certain amount. So the increase, it went up to 10.10%, I believe, and it went up from, subject to check, I think it was about 985 and went up to 1010 after the 30-year treasury had trended high enough, long enough to trigger that mechanism.
So is that an automatic increase? And how does that mechanism work?
It is automatic. I mean, the company has to track it and then, meet the parameters of time. And then to my understanding, we, filed to implement the increase.
Okay. All right. Is that type of mechanism widespread across the country to your knowledge?
I don't believe it's widespread. I mean, we have in Florida, and I think we modeled it, I believe, off of the FPL, which is noted on the table there, that there's an ROE trigger. My guess is there's others across the country, but I can't cite them.
Okay. All right. Any additional questions from commissioners? All right. Questions on commissioners' questions? Any from the company?
Just a few,
Okay,
Chair Mitchell.
go ahead.
And the first one is really more of a update to the commission because Moody's came out with a credit opinion for DEP last Friday, I believe, which of course could not have ever been marked as a potential exhibit, but it updates the one that Mr. Newland spoke about back when he was here on direct. We have marked it as a potential exhibit. Not that one there. Potential redirect exhibit 17, and have copies for the commission. I would like to be able to go ahead and introduce it into evidence since it does in effect supersede the credit opinion that Mr. Newland was asked questions about earlier in the case. It probably won't be in your electronic files because it was just done last Friday. So if we could go ahead and have these distributed to council and the commission, that would be great.
Chair, if I could object to that before we just start distributing them.
All right.
I'd object for two reasons. First is it was served on May 12th, but my witness was excused on May 11th, so I don't have the ability to counter it. And second, and I'm going from memory here, but I feel like North Carolina Justice tried to move something from like Hawaii into evidence, and Duke said, well, if it's not marked, it's not, we object to it. So for either of those reasons, I think it should be excluded.
Okay, just for clarification, Mr. Freeman, when you say it was not served, what do you mean?
The document that is being referenced was served, emailed to the parties on May 12th.
Okay, so the document that Mr. Mehta is referencing was emailed to the parties on May the 12th.
There's a certificate of service for May 12th.
Okay.
I believe that's correct, but it was also the date that it was published.
Okay. Let me hear from you, Mr. Shower.
Sure. So just briefly to add, I mean, the commission, I believe, did enforce the requirement against Mr. Neal that exhibits that were not filed consistent with commission's orders before the hearing would not be admitted. And I believe Duke is asking for an exception to that rule. A document that we cannot respond to based on our expert witnesses because they are excluded. So we do feel like this is an unwarranted exception.
And Chair Mitchell, I'm sorry, go ahead.
I would just add that I also don't believe that this is responsive to any commissioner questions. So I'm not quite sure how it's coming out now and on questions on commissioner questions. So I would add that as another reason for the objection.
And Chair Mitchell, I just joined everything that my colleagues have said. I was going to add exactly what Mr. Neal stated, so.
All right, Mr. Mehta.
Let me take them from the back first. Yes, I do not believe this particular document would respond to a commissioner question. However, up until the witness was made available for cross-examination, he had 155 minutes of listed cross-examination in the updated witness list that was circulated this morning. So I believe that once again, we are faced with a situation in which very strategic decisions about cross-examination are being made to prejudice the company, which has the burden of proof in this case, in the presentation of its case. That deals with the last of the objections. In terms of the Hawaii decision that Mr. Neal sought to introduce, that Hawaii decision was not just reported, as far as I know. It was actually listed in his exhibit. He wanted to introduce the decision itself. There is no reason on earth the decision itself could not have been listed as a potential exhibit at the time that the exhibit in which it was referenced is listed. This document is dated May 11th, 2023, and was published by Moody's on May 12th, 2023. It was served on the parties as a potential redirect exhibit on the date it was published. There is no way for Duke Energy Progress to have listed it prior because it didn't exist prior to May 12th, 2023. So for those reasons, I believe that these objections are completely unfounded. This is not an exception that Duke is seeking to the rule. It is essentially an enforcement of the rule, pretty much the same way that Counsel for Sigfer updated various of her potential exhibits because they weren't available prior to the time that the commission's order required the redirect exhibits to be pre-filed.
I will take the matter under advisement. We've reached our lunch break and we will be back on the record at 2 o'clock. Let's go off the record, please. right, just a reminder, we will end at 4 o'clock today. We're going to go straight through to 4. I will allow the document in. Please pass it out to the commissioners and to the witness as well, and opposing counsel.
Thank you, Chair Mitchell, and I think Ms. Smith is in the process of doing that.
Mr. Mehta, would you, while the document's being passed out, would you please confirm for me that this document was in fact provided to council?
Certainly, Chair Mitchell. I'm looking at an email that Ms. Athens sent to all parties dated Friday, the 12th of May. The timestamp on it is 1:49 p.m. It circulates an updated exhibit list, potential redirect exhibits, and this particular exhibit, which is pre-marked as number 17.
All right, in the interest of fairness and due process, I'm going to allow counsel, opposing counsel, to ask the witness questions on this document if you so choose. Duke, you will have an opportunity to ask questions after counsel asks their questions.
So Chair Mitchell, I would like to ask, I guess, a few questions on this.
Go ahead.
Mr. Newland, I'm looking at what has been pre-marked as DEP potential redirect exhibit number 1. Do you have or number 17? Do you have a copy of that in front of you?
Yes, I do.
Looking at the front page, am I correct that this graph shows the last data point for CFO pre-working capital over debt is 16.8%?
That's correct. We typically call it FFO to total debt.
Okay, thank you. So the FFO to total debt dropped below 20% as of this credit report?
It did. If you reference the footnote, it's because of the high fuel balance at the year end. And so if you adjust for the fuel balance, it'd be 20.5 in the footnote.
Right. And am I correct that despite it dropping below 20%, the company's debt rating remained the same?
It has remained the same, yes.
Would you turn to page 8 of the exhibit, please? Where it identifies the 4 factors.
Yes.
Are you familiar with this methodology scorecard?
I am. Yeah.
Am I correct that the FFO to debt ratio is factor 4B, according to this chart?
Correct.
Okay, and factor 4 is weighted 40% according to the score?
Correct.
Which means factor 4B, which is one of the 4 factors, would be effectively rated 10%?
Yeah, I don't know if they equally split it amongst the 4, but it's clearly a component of factor 4.
And then I note that factor 4B is a 3-year average. Is that
Correct. Yes.
Which means a single year would be 1/3 of what Moody's will look at under factor 4B.
That would be 1/3 3-year average. That's right.
Okay. And so effectively 1 year of Duke's FFO over debt would be potentially 3.3% of the scorecard weighting.
Well, again, I don't think they equally weight the 4 within factor 4 because they do put a lot of emphasis on FFO to debt. That's really the metric we talk about the most. I would think without them prescribing a weighting within factor 4, I think they probably focus more on it than others.
Looking at factor 2, where it talks about ability to recover costs and earn returns. Do you see that?
I do.
And that's allocated 25%, correct?
Correct.
The timeliness of recovery of operating and capital costs, which is subfactor A, and then the sufficiency of rates and returns, which is subfactor B, those ratings would be, or those factors would be impacted by the commission's potential approval of a multi-year rate plan. Am I correct?
Yes.
Right. And those would be credit favorable. And a multi-year rate plan would be credit favorable, correct?
Well, they look at a number of things that go into but clearly the multi-year rate plan would be a component of what goes into that factor too.
In fact, looking back at the front page, speaking of the multi-year rate plan, I'm looking at the summary paragraph. Third sentence, it says North Carolina's House Bill 951, signed into law in October 2021 to guide the state's clean energy transition, will be an important driver of the company's credit quality going forward. That House bill included a multi-year rate plan, did it not?
Yes, I believe it did.
Okay. All right, no further questions. Thank you.
Thank you, Chair Mitchell. Mr. Newland, could you turn with me to page 2?
Council, you got to talk into your mics. Everybody make sure you pull the mic as close as you can to you so that we can all hear you. Thanks.
Could you please turn to page 2
Okay.
and read into the record the first bullet listed under factors that could lead to an upgrade?
Credit positive changes in the utilities regulatory framework, including more riders and trackers to reduce regulatory lag and improve cash flow.
Could you please turn with me to page 3? Do you see in the first paragraph under the section that starts out with North Carolina in bold, the sentence, in addition, the law authorizes the NCUC to consider multi-year rate plans and PBR as well as revenue decoupling, a mechanism we view as credit positive?
Yes, I see that.
Thank you. No further questions.
David Neal for NCJC et al. Briefly, just on that same theme, if you could, following Ms. Kress's questioning, on the towards the top of page 3, do you see where it says, however, North Carolina, it's the I think the first full paragraph before the bold North Carolina. There's the second sentence there. Are you with me?
In the first full paragraph?
Where that starts, despite this generally. Do you see that?
Yeah, I see that.
And then the next sentence, I think, says, however, North Carolina's new performance-based rate making, PBR framework, as authorized in HB 951, is a potential development towards mitigating regulatory lag. You see that?
This is positive development.
Yes.
Yes.
Yes, thank you. And were you heard the testimony of witness Morin earlier in this proceeding, yes?
Yes, I did.
And do you recall a conversation, I believe it was in response to commissioner questions, where there was a discussion about would there be any potential credit rating impacts from the South Carolina decision to impose a 9.6% ROE following the settlement in the South Carolina case? Do you recall that discussion?
I remember that discussion, yes.
And if you turn with me to the top of page, well, the bottom of page 3, there's the South Carolina you see in bold.
Yes.
And that paragraph about South Carolina continues onto the 4th page. And you see that the Moody's report here references that 9.6 ROE and 52.43% equity layer here in the opinion, yes?
Yes.
And that didn't result in any sort of downgrade, did it?
It also notes South Carolina is under 15% of rate base, but you're correct. The decision did not result in a ratings action.
Thank you, that's all.
Mr. Newland, my name is Will Freeman. I'm here for the public staff. Potential exhibit 17 or pre-marked exhibit 17 has 2 good things for Duke Energy Progress. First is it has this A rating, which is great, right?
Correct. They affirm the rating. Correct.
And second is it remains stable also, right?
Correct.
If Moody's wanted to give you a signal that they were worried, they could have changed that from stable to negative, correct?
They have other signals they give, but they could also do the negative outlook. That's right.
So we didn't get a negative outlook in this document, correct?
We did not.
So Duke, this is good for Duke's credit, correct?
This report affirmed the ratings. It's good to have ratings affirmed.
And if you, last year, in the credit report that came out before this, Moody's forecast that Duke's funds to the debt ratio, which is that FFO, CFO, okay.
To debt, right?
Right, to debt ratio would be 20 to 22%.
Right.
Now we're 200 basis points lower and they're still with this good A and we're still at stable, right?
We are. I would say there's warning language within the document talking about where we're headed, but you are correct.
And I think we've got an spend of about on average $3.2 billion through 2027.
For the capital,
Right, that's what Moody's thinks, right?
it was a little bit more. I thought it was almost per year, 2.5 billion per year, but subject to check.
I was getting it from page 5. We don't have to be subject to check. If you'd like to look at that, capital expenditures will remain substantial paragraph.
Where are you looking?
You see the heading that says capital expenditures will remain substantial. There's a little paragraph right under it.
Right.
From 2023 onward, the company forecasts capital spending to accelerate once again, averaging around 3.2
Yes,
billion.
per year. I'm sorry. I thought you meant through 27.
I
In
apologize.
total, no, per year. Agreed. Yes.
And yet, if we look on page 7 of this document, we expect Duke to maintain an adequate liquidity profile. That's under the liquidity analysis on page 7.
Well, they expect us to. That's a kind of a mission. You know, when they said they expect you to, they're telling us they expect us to maintain that to hold the rating.
And just to flesh out a conversation you had, if we look at the scorecard, I think we'd said 40% was allocated to this debt ratio. The whole factor 4 was financial strength. That's 40%.
40% of financial strength, correct.
If you'd like to look at tab 109, you're free, but we entered it into evidence on your direct and they rank item B at 12.5%. Does that seem?
I was unaware of that. If they individually weight the sub factors, I was unaware of that.
They do. If
Okay.
you'd like to look at tab 109, you're welcome, or you can do the subject to check and take my word for it.
I'll take your word for it, subject to check.
Okay, so the funds to debt ratio that we've been talking about, 12.5%. So we're spending a lot of effort on 12.5% of this sheet.
Yeah, I will tell you as a practitioner, they focus on that metric a lot.
If you would look with me on page 9 of this document, it's the peer comparison table there at the bottom.
Okay.
You see, they've identified 3 peers. Duke Energy Progress is the first one. You see where I am?
Yes.
Okay. Then they have Dominion Energy South Carolina, Duke Energy Carolinas, and Georgia Power Company.
Okay.
So I noticed that Dominion Energy South Carolina and Georgia Power Company, the peers according to Moody's, do not have an A2 rating. Correct?
Correct.
They're stable at BAA1 for both of them.
Yes.
And now that BAA1 is one notch below where we are.
It's 2 notches. You go
Okay.
A2, A3, BAA1, so 2 notches.
2 notches below.
Correct.
And so they consider these 2 companies peers, even though they're a couple of notches below Duke Progress.
Yes.
I think that you said, so I want to take this chart. If you're let's say you're 1 notch below, 2 notches below Duke. If you're going to go down 1 notch, that's 5 to 10 basis points. And if you go down 2 notches, that's 10 to 20 maybe, right?
I have that in my rebuttal testimony. That's correct.
Okay. So I feel like Duke's cash flow negative right now. Duke Energy Progress, I'm sorry. I want to be clear about that.
Yeah, that's true. Yeah.
And they're going to need several $100 million for each year of the multi-year rate plan.
Correct.
Plus, we've got some long-term debt that is going to
mature.
Exactly. So we're needing $1 billion a year for the next 3 years, maybe 1.5.
Yeah, I mean that ballpark's correct. Yeah.
So I'm going to say 3, 4, 5 billion. I don't want to put words in your mouth. Is that a fair range?
That's a fair range.
If we were to borrow $3 billion at 10 basis points, That's 3 million extra dollars that we're going to have to pay if we go down one notch, right?
Extra dollars, correct.
And of course, if it's $3 billion and 5 basis points, 1.5 million.
Yes.
Okay. So if we do go down a notch, which the public staff, as you know, our witness said we didn't think we would, but if we do go down a notch, it's only $1 million or $2 million. But, and let me just follow up, don't we get a ton of like flexibility for running the risk of going down one notch, which would still be one notch higher than our peers? Like, I feel like that you get a ton of flexibility and it doesn't cost a lot of money. Can you help me with that question?
It'll be more expensive, no question about it. Whether it's 5, 10, or 20 basis points, it'll be more expensive. So I think that's pretty apparent. I think you do lose some flexibility on access to the market on days where it's either a no issue day or there's a lot of exogenous events where it's difficult to access the market. Typically access comes at a price. So again, if there's a day where it's difficult to issue, if you're not as strong a credit quality as you were before, you're going to pay up to access the market on those days.
But doesn't that $1.5–3 million buy ratepayers a much lower bill?
In the short term, it might, but over time, as that debt reprices, you'll have much more cost flowing through your rates.
I understand. If you'll give me one moment, I think I'm complete. Thank you. I don't have any more questions. Thank you.
All right, Mr. Mehta, you may ask, just proceed.
Thank you, Chair Mitchell. Mr. Noonan, why don't you keep that document in front of you? And Chair Mitchell, I'd like to go ahead and mark it as, I guess it will be, get my cheat sheet out. DEP redirect Newland rebuttal exhibit 1.
Chair Mitchell, SIGFR 2 renews its objection.
Noted. All right, the document will be marked as DEP redirect Newland rebuttal exhibit 1.
Can we also just, for the record, renew our objection?
Noted.
Thank you.
Anyone else?
CUC, I would like to as well.
Same.
Chair Mitchell,
Sorry, NCJC et al. Same renewal.
Will you please just specify what you are putting on the record?
Sorry, I was trying to be brief. Renewing the objection to the admission of this exhibit.
All right, Mr. Mehta.
For the reasons previously stated, Chair Mitchell, I believe that the exhibit is very appropriate to be placed into the record and admitted into evidence at the appropriate time. The interveners have already had the opportunity to examine the witness on the record. I believe the company should also have the opportunity to examine the witness on the record with respect to this particular document.
Proceed.
Thank you, Chair Mitchell. Mr. Newland, Mr. Shower for CUCA asked you questions concerning what's now been marked as Exhibit 1 for purposes of this examination. Regarding the timeliness and whether HB 951 would assist with the timeliness of recovery of costs, correct?
Correct.
If you would, Mr. Newland, look at with me parts of the document that Mr. Shower did not point out to you. For example, right at the bottom of the first page, Moody's indicates regulatory lag due to lack of rider tracker mechanisms for cost recovery is one of the credit challenges facing the company, correct?
Correct.
Chair Mitchell, if I could just object. Mr. Mehta is adding a lot of commentary to his questions. If you could just stick with questions.
Overruled. Overruled. We are ending at 4 o'clock today. Let's keep our objections brief and let's get through this. Go ahead, Mr.
Thank you, Chair Mitchell. If you look at page 3, one of the intervenor counsel asked you to read the first sentence of the first full paragraph. Actually, part of a sentence of part of that sentence. The part that was left out was utilities in North and South Carolina do not benefit from tracking mechanisms that could serve to reduce regulatory lag.
The first part of that paragraph says that. That's correct. Yeah, I read the second
You,
sentence.
you read the
First-
second sentence
The first
that
sentence
says,
says utilities in North and South Carolina do not benefit from tracking mechanisms that could serve to reduce regulatory lag.
and failure to reduce regulatory lag is an indication that the company may not receive timely recovery of costs and investments that it makes, correct?
Correct.
If you go on to page 4, we see the sentence right below the heading, financial metrics are expected to remain supportive. Do you see that?
Yes.
Second sentence, nevertheless, recovery of ongoing coal ash remediation spending, which still must be recovered via general base rate case proceedings and storm costs, along with elevated spending for grid modernization, will maintain pressure on credit metrics. You see that?
It says that, yes.
And that's, again, an indication of regulatory lag that is still embedded in the system despite House Bill 951, correct?
Correct.
So just to make sure that the record is clear, Mr. Newland, the lack of trackers and riders, HB 951 does not alleviate that, does it?
No, it has mechanisms that help, but does not alleviate the issue.
Yeah, HB 951 itself is not a tracker or a rider.
That's correct.
Regulatory lag with respect to storms, which are increasing in frequency and ferocity, HB 951 and the whole PBR mechanism does not alleviate regulatory lag with respect to that, does it?
It does not.
Coal ash recovery, cost recovery, for which there is no tracker, HB 951 does not alleviate regulatory lag with respect to that, does it?
It does not.
HB 951 forces elevated spending for grid modernization, which actually puts pressure on the company's credit metrics, does it not?
Through the carbon plan, that's correct.
Let's turn to some of Mr. Freeman's questions. He indicated that at least two things in the Moody's opinion dated May 11th, 2023 were positive for the company, right? It maintained its A-level ratings and Moody's maintained a stable outlook.
Correct.
And so I think his question was phrased in, there are no signals in the Moody's report for which the company should be worried about a downgrade. Words to that effect, you recall that question?
He said those are good things for the company, and I agreed. Those are good things for the company to have the rating and be affirmed.
Okay. Mr. Newland, when you were here before, we looked at a document that was marked as a potential rebuttal exhibit, and it was the November 2022 Moody's credit opinion, or it was an outlook document. potential redirect exhibit 11. Chair Mitchell, for purposes of the record, this was introduced into evidence as DEP redirect Newland direct exhibit number 3.
And Chair Mitchell, I would just object as outside the scope of the cross-examination. Mr. Mehta has had a lot of leeway this afternoon, and I think he has stepped far afield of the scope of cross.
Chair Mitchell? Well, I'm sorry, have you finished? The question from Mr. Freeman was directly phrased in terms of warning. This is part of the warning.
All right, I will overrule the objection and allow the question.
Mr. Newland, this is the document in which Moody's essentially put the industry on notice of potential downgrades, correct?
I'm sorry. What was, I know that document. What was the date of that one again?
November.
Yeah, 22. Yes.
22.
The industry, that's correct. Yeah.
Mr. Newland, look also, if you would, at what was previously, or what was marked as redirect. Let's see, DEP potential redirect exhibit number 9. Chair Mitchell, this one was introduced into evidence as redirect Newland direct exhibit number 1. Have you got the document?
Yes, sir.
This is the document in which in April of 2023, Moody's raised the downgrade threshold for DEP from 20% to 21%, correct?
That's correct.
So, Mr. Newland, is it fair to say that the November 2022 industry document was a shot across the bow? A warning shot?
I would agree with that, yes.
Is it fair to say that the April 2023 document was a shot across the bow a little closer because it's directed specifically at DEP?
Yes, and it raised that downgrade threshold of the FFO to debt, so it was very specific.
Look also, if you would, Mr. Newland, at DEP potential redirect exhibit number 12, which is the prior Moody's report.
Okay.
And Chair Mitchell, this was introduced previously as DEP redirect Newland direct exhibit number 2. Now, Mr. Newland, I'd like for you to keep that document open and then go to the most recent Moody's credit opinion, which is DEP redirect Newland rebuttal exhibit number 1.
Okay.
Have you got them both?
Yeah, I do.
If you look at the prior document, 12, potential exhibit 12, and I'm looking on page 3 at the very top of the page, factors that could lead to a downgrade.
Yes.
A ratio of, we'll just call it FFO to debt, excluding the financial effects of storm cost, remaining below 20% on a sustained basis. Is that what Moody's said?
As a factor that could lead to a downgrade, correct.
If you look at the more recent credit opinion that came out last week, and you look at on page 2, factors that could lead to a downgrade. The third one is a ratio of FFO to debt, again, excluding storm securitization, remaining below 21% in 2023, correct?
Yes, that's what it says. So they moved the 20 to 21%, and they went from a sustained basis to specifically calling out 2023.
Have you seen in recent memory Moody's calling out a specific year for the company?
I do not, especially when they affirmed a rating. And they put out these reports once a year on each of the issuers. And so I think they choose their words very carefully when they do that.
What year are we in, Mr. Newland?
2023.
So is this a shot across the bow that's getting really close to the bow?
Yes.
Mr. Newland, one other question about this document, or at least pertaining to this document. I believe Mr. Freeman drew your attention to Georgia Power Company as a peer. And I can't remember the page, but it's one of the page 9, actually.
Yes.
If you would look at your rebuttal testimony, page 34, table 4.
Table 4?
Yes.
Yes.
What is the current authorized ROE for Georgia Power Company?
10.5%.
Mr. Newland, in the commissioner question portion of this examination, Commissioner Mitchell asked you about credit spreads. Do you recall those questions?
Yes.
If you would look at what has been previously marked as.
Mr. Mehta, I want to stop you. Since have you completed your questions on your redirect of your witness based on questions asked by opposing counsel on this Moody's document?
I have,
Okay,
yes.
let's do this. We've got some questions from commissioners on the Moody's report. I'm going to go through questions on commissioners, and then you all will get another chance to ask questions on commissioners' questions. And then we will resume with the completion of your questions on the commissioners' questions that were asked of the witness prior to the Moody's report.
Understood. Thank
Okay.
you, Chair Mitchell.
So let's do this. Commissioner Brown Bland. Okay, Commissioner Clodfelter.
Mr. Newland, very quickly, one thing caught my eye that you haven't been asked about, and I'm just curious, you don't have to have it in front of you. It's on the most recent May 11 credit opinion from Moody's. You don't have to have it in front of you, but it notes in there that you've got a $300 million first mortgage bonds maturing in September of this year. By any chance, are any of those bonds associated with either the Mayo or Roxborough steam stations?
I do not know. My apologies. I do not know. If they're under the indenture, they're secured by all of the indenture, all the property within the indenture.
So these are not, if they're in the general indenture, these are not specific to Mayo or Roxborough.
That's correct.
That's sufficient for the question I was going to ask. Thank you. Nothing further.
All right, Commissioner Duffley. Okay. Commissioner Hughes. Commissioner Hughes. Commissioner McKissick.
One. I only ask this question because I haven't heard anybody get into this particular issue that's part of the most recent report, the May 11th report. And that is dealing with ESG considerations. And of course, it shows a score of CIS 3, moderately negative. And it is broken down into subcomponents: environmental, E4, social, S3, governance, E-2. Now, in terms of environmental E4, I was just wondering, what are your thoughts about a score in this level? And when I looked at the prior report from last year, it hardly made any mention at all of ESG factors. So, I mean, the fact that they have now moved into a more thorough evaluation and a more detailed analysis of the subcomponents causes me to wonder, you know, what is it about Duke in this area that is raising concerns that has potential implications as it relates to credit metrics moving forward, particularly since they, you know, under that E4 get into far more detail about why there are certain risks that appear that they could present problems in the future. So you could compare and contrast last year's report to this one and then comment upon their characterizations under this category.
Sure. So really both major rating agencies have enhanced their reporting, if you will, on ESG factors. Both of them have come out with fairly extensive reports talking about the ESG impacts really amongst all three of those buckets, the environmental, the social or sustainability, and the governance side. They've all been, both of them have been, I think, careful in saying that, this is information for investors to consider, for debt investors to consider, but it doesn't necessarily affect the rating right now. We expect, I would expect over time that those ESG considerations and factors will flow more into their decision on making ratings decision. But as of now, they claim they don't. So when they rolled it out, I think a year and a half, maybe 2 years ago, it was cursory, and today it's gotten more in depth, as you rightly point out. For the environmental score, some of it, in fact, most of it is a legacy of our generation fleet. So we have existing coal, and that's, when they compare us to other companies, that's the existence of that is going to affect that score versus some other companies. They cite nuclear as just having potential risk around if there, heaven forbid, if there was an accident, what it would do. And then they also cite certain things about the service territory by which we can do nothing about. So just the fact that we are more susceptible to hurricanes, given where we're located, that can cause more physical damage to the system than if you were in, say, the Midwest. And so some of those factors that they highlight, they recognize there's really nothing the company can do about them, the geographic location. And then other of the items, such as your generation stack, et cetera, those are things that they consider you can make changes to over time, which, as you know, we're attempting to do.
So I guess when it comes to the coal generation, we all know about the closure plans that are currently in place. And so, and the nuclear, I'm not sure what more can be done in that area. There's about 50% generation of nuclear for this particular territory, in terms of what it contributes to power generation, I guess, portfolio. That's a better way of putting it. But are there any things, and you can't change the location of the geographically.
Correct.
So what could be done to mitigate impacts, potential impacts from this area moving forward? Because they do rate it as highly negative.
Yeah,
it's more than just negative. It's to the left, and in this case, left is more serious than it would otherwise be.
I think we can do the things that we're attempting to do under the carbon plan, that being to strengthen the system against storms, storm hardening, we often call it. The distributed nature of generation going forward, I think, will help to mitigate outages. And then a lot of the other work that they're doing in the transmission system, the self-healing grid, things of that nature to make it more resilient to the storms that will come in the future. So I think we're doing a lot of those things. The one thing that, we look at this is, because this is our company, we look at this, but as an investor, you would look at this against all the other investment opportunities that you have. And so if you're an investor that was particularly interested in, say, perhaps that ESG factor, you could compare that E4 to maybe a company that's located elsewhere that doesn't have the hurricane risk or doesn't have generation, and just be a T&D company. So just as a reminder, a lot of this is meant not just for us, but also for the investors that make investment decisions every day with their dollars.
Thank you for those observations. I was just curious what your thoughts were, particularly comparing the two reports.
All right, questions on commissioners' questions?
No questions. None from Duke.
Mr. Mehta, you may continue with your questions on commissioners' questions that didn't relate to the Moody's report.
Mr. Newland, you recall the questions from Chair Mitchell concerning credit spreads.
Yes.
Would you turn to potential redirect exhibit number 8
on there?
Chair Mitchell, this is a document with a title Indicative New Issue Spreads. And I'd like to go ahead and have it marked as DEP Redirect Newland Rebuttal Exhibit 2.
All right, the document will be marked as requested by council.
Mr. Newland, you might be the only person in the room who knows what an indicative new issue spread is, so why don't you just explain it to the rest of us?
So this is a pricing sheet. So this investment bank, Scotiabank, has sent around a pricing sheet to us, and most of the banks in our relationship do, where they're showing what their estimated coupon would be for debt being issued at each one of those tranches for each one of those issuers. So if you look in the 30-year column, you can see what the coupon is expected to be if you were to do a new issue from each one of those issuers as of that date. And
that date is April 27th?
Correct, of 23. And then the shaded area is the spread. So I was talking earlier about a spread over the relevant treasury. So here, a 30-year bond, the spread would be over the 30-year treasury at that time.
So in this particular instance, then, if you just focus on the 30-year bond, if Scotiabank is telling, and does this come out regularly? Something like this come out regularly from Scotiabank and other banks?
Yes, usually weekly they like to send this to my inbox.
And they're basically saying if you're going to place some debt issue, for that date, this is what you can expect to pay for it.
Correct.
So if we focus on the 30-year column, DEP is 150 basis points above the
30-year
benchmark.
treasury. Right, correct. The benchmark treasury, correct.
So their prediction is it would have been priced at 5.24% at that time.
Correct.
Which is 150 basis points above 3.74%, which is the 30-year bond.
Correct.
And you were describing to Chair Mitchell how the spreads widen as the credit rating of the issuer drops. Could you show how that works on this exhibit?
Sure. So Duke Energy Progress at AA3 as an issuer would come at a 150 basis point spread to the treasury, as you pointed out. If you go down to, say, Duke Energy Ohio, which is an A2 rated credit in our complex, it would come at 165 basis points over the relevant treasury. So a 15 basis point wider spread because it's A2 instead of AA3. So that's a 2-notch downgrade, 2 notches below, I should say.
And then how about Duke Energy Corp?
Yes, Duke Energy Corp is lower rated still, so they're a Baa2 rated entity, and so they are estimated to come in 185 basis points over the 30-year treasury.
So that spread difference would be 35 basis points.
Correct.
And if you're financing billions of dollars worth of debt, or let's just call it an even billion worth of debt over a year, 35 basis point spread is a considerable spread. Is it?
Yes.
I think that's all, Chair Mitchell.
All right, with that, Mr. Newland, we have come to the conclusion of your testimony. Thank you for your testimony today and your participation in this case. You may step down and be excused, and Mr. Mehta, I will take.
Chair Mitchell, I would move the introduction into evidence of DEP Redirect Newland Rebuttal Exhibits 1 and 2.
And Chair Mitchell, at this time, Sigford 2 would renew its objection and move to strike DEP Redirect Newland Rebuttal Exhibit number 1.
that
Public
motion.
staff would make the same motion, understanding the court, the chair's arguments.
The motion is denied. I will allow the to redirect exhibits into evidence. All right. Let me just confirm, Mr. Mehta. There were no exhibits. There were no
And
exhibits.
there
that-
were exhibits to Mr. Newland's rebuttal testimony. I believe they're 1 through 6, and I would move their introduction as well.
All right. Let's see, just give me a moment here. There were 6 exhibits, so those 6 exhibits will be admitted into the record.
Thank you, Chair Mitchell. And at this time, DEP calls LaWanda Jiggets to the stand, but she's already at the stand.
All right, Ms. Jiggets, just a reminder that you are under oath.
Ms. Jiggets, you've previously testified, but please state your full name and business address for the record.
LaWanda Jiggets, 410 South Wilmington Street, Raleigh, North Carolina, 27601.
And by whom are you employed and in what capacity?
I'm a Rates and Regulatory Strategy Manager with Duke Energy Carolinas, testifying on behalf of Duke Energy Progress.
Ms. Jiggets, you previously filed direct supplemental and settlement testimony in this proceeding?
Yes, I did.
Now, on April 14th, 2023, did you pre-file or cause to be pre-filed in this docket rebuttal testimony consisting of 59 pages?
Yes, I did.
Are there any corrections you need to make to your pre-filed rebuttal testimony?
No, there aren't.
If I were to ask you the same questions today under oath, would your answers be the same as those set forth in your pre-filed rebuttal testimony?
Yes, they would.
Chair Mitchell, I move that Ms. Jiggett's pre-filed rebuttal testimony in this docket be copied into the record as if given orally from the stand.
All right, the pre-filed rebuttal testimony of DEP witness Jiggets filed in this docket on April 14th, 2023, consisting of 59 pages, will be copied in the record as if given orally from the stand.
And Ms. Jiggets, did you prepare or cause to be prepared a summary of your rebuttal testimony that was pre-filed in this docket on May 10th, 2023?
Yes, I did.
Chair Mitchell, the summary was pre-filed on that date, provided to the commission and all parties in accordance with the commission's instructions, and I ask that it too be entered into the record as if given orally from the stand.
All right, the summary of the witness's testimony will be copied into the record as if given orally from the stand.
And Chair Mitchell, again with that, the witness is available for cross-examination. I'm not sure there is any cross-examination and any questions from the commission, and I would just renew my observation, Chair Mitchell, concerning the strategic withdrawal of cross to the extent necessary. It certainly wasn't necessary with the COVID panel as a result of the commission's extensive questioning. But again, there is aspects of public staff's testimony that the company believes is misleading, and we were not able, because of the placement of that testimony in redirect to commission questions, to actually challenge it.
All right, let's do this. Commissioners, who has questions for witness Jiggets? No questions. All right, Ms. Jiggets, I have a few for you.
Okay.
All right. Let's turn to pages 27 and 28 of your rebuttal.
Okay, I'm there.
Okay, give me 1 minute to get there. Okay. All right, on those pages, Ms. Jiggets, you discuss the public staff's adjustment to rate case expenses to exclude costs associated with a company's last general rate case. you state that you provide the company's position, which is that it does not agree that these amounts should be excluded from recovery. And generally that the company isn't precluded from collecting additional amounts based on what was agreed to in the previous case. Is that correct? Do I state the company's position correctly?
Yes, that's our position.
Okay. Are you aware of any other instances where the company has sought recovery of additional rate case expenses in a subsequent rate case?
No, I believe as witness Bateman kind of testified when she was before you previously, what we have typically done is in instances where we have had actual costs for a prior rate case be more than what we included in the rate case, we've just allowed the amortization established in that case to continue until the actual amount of costs were recovered. In this instance, because the amount of the difference was so large, we thought it was in the interest of transparency to pull that full amount forward and ask for it in this manner, because it would allow all parties a chance to see how much those cost differences were and to review the costs as a part of this proceeding.
Okay. To your knowledge, did the public staff review those expenses?
Yes, we did receive a data request asking for details of those costs, and they were actually provided as a part of Public Staff Data Request 96-1.
To your knowledge, did the public staff challenge any of those aside from taking the position that they shouldn't be allowed to be, the company should not be allowed to recover those costs? Did the public staff otherwise challenge any of those
To my
costs?
knowledge, we were not, did not receive any feedback that those costs were unreasonable or imprudent.
Okay.
I'll exhibit, I believe Ms. Duffley asked for it, Commissioner Duffley asked for it from Laura Bateman. We have been working on that, and I believe it has been provided, and it lays out the details you're asking for with respect to a timeline for those charges and a comparison of how those charges compare to what was included in the initial settlement in the last case. But for your benefit now, I'll kind of also try to walk you through it as well. I don't have the full example here with me, but I do know the general timeline. The settlement was originally reached with the public staff in June of 2020. That amount included $3.5 million as the rate case expenses that we will be recovering in the revenue requirement in that case. That included actual costs as of February 2020 and an estimate of costs that we thought we would incur through August of 2020. The actual hearings, the consolidated hearings, I believe, happened at the end of August of 2020. We had interim rates that went into effect in September of 2020. The individual hearing for DEP happened, I believe, late September, early October of 2020. The CCR settlement was essentially reached in January of 2021. The order in that case came out in April of 2021, and then new rates went into effect in June of 2021. So that's the elongated period that I believe you heard me talk about when I was before you previously. During that time frame, obviously, we had additional discovery that required, questions and responses. We had the prep and the times for the hearings. So all of that kind of led into the cost being more than what we initially estimated at the time of settlement in June of 2020.
All right. Thank you, Ms. Jacobs. On page 29, you indicate, let's see, I can't tell you the line number, but you indicate that the company plans to continue to track costs associated with this proceeding for possible recovery in a future proceeding. Do you remember that testimony?
Yes, it's towards the end. I believe that specific line is on line 21. The company plans on continuing to track costs incurred during this case through the rate's effective date for possible recovery in a future period. I think that goes back to we always include, even for rate case expenses for this current case we're in, we have actuals and an estimate of what we think we will incur through the hearing date. To the extent those actuals are different from that estimate, we would track those.
Okay. So the company isn't asking the commission to take any action on this at this point in time, just informing the commission of. the
Correct.
company.
I think it was more just so that it was clear, this is what we have done historically, but making it clear in reference to this, that, you know, we will take the same process and track what our actuals are in relation to the projection that we have included in the revenue requirement in this case.
Okay. And Ms. Jiggets, I don't want you to leave here before I have, or at least attempt to have an understanding of the company's position on Winter Storm Izzy expense. I believe it's been a long couple of days or weeks now, but I believe I heard Ms. Boswell testify that the public staff's position is that the public staff supports a deferral of Izzy and Ian.
Correct. Like, I think we have now gotten to the point, whereas, again, I think in their initial testimony, they were not in support of the deferral for Winter Storm Izzy. We both now agree on the deferral. We differ on the method of recovery for that deferral.
Okay, so when you say you agree on the deferral, do you all agree on the amount to be deferred?
We do. We are proposing to defer the amount that is above the base level storm expense as established in docket E sub 2 1142 of $27.4 million. So that gets us to about, for the storm year, we had $40 million of expenses for North Carolina retail. Taking into account that base level requirement, we're requesting to defer the difference, which is about $15 million through my third supplemental updates and in my partial settlement.
And that's for both of those storms?
That is just for Izzy.
Okay. So 15 million for Izzy, and then what about for Ian?
Ian is going to be about 53.
Make sure I have.
Excuse me, let me make sure, double check. I believe the 53 was system. Give me 1 second to double check. I'm going to look at NC pro forma 7010.
Okay.
Yeah, so the 53 million is the system number. I would be proposing to defer the NC retail share of that.
Okay. Okay, and then so you said, it sounds like the company and the public staff at least have come to some meeting of the minds on the amounts to be deferred. And then you indicated that the public staff and the company disagree on
The
recovery
method of recovery for Winter Storm Izzy.
for Izzy.
For Izzy. They are proposing that we would securitize Izzy along with Hurricane Ian. We are proposing that we would use the over amortizations associated with Hurricane Matthew to fully recover that amount.
And so, but both parties agree that Ian is to be securitized.
I believe so, yes.
Okay. Okay, thank you for your testimony. That helps me. All right, let me just go through my notes one more time. Ms. Jiggets, do you have at this point, does the company have an understanding or an idea of when it would take action to securitize those costs?
I do not.
All right, Ms. Jiggets. I have nothing further for you. Let me, you have one? Okay, go ahead. Commissioner Gladfelter.
I want to follow up the chair's questions just to be sure I understand. It would help me understand the company's proposal for what to do with the unamortized balance of the rate case expense from the E2 sub 1219 proceeding. I understand you went through that. It would help me to understand that proposal to then understand the prior history that you talked about, what was done in the past. And so, so that I can understand the mechanism for the past, let me give you my case and tell me how you would handle it, would have handled it in the past.
Okay.
So you're in rate case A and you've got rate case expense. And let's say you're granted, the commission approves a 3-year amortization of that rate case expense. And you find that at the end of the 3rd year, you still haven't fully amortized. You've still got some unamortized balance. So I understand your testimony was that you'd then continue that into year 4. You'd actually continue it until you'd fully amortized it. Now, so here's the question I want to be sure I understand. Let's say you're in year 3, commission's allowed 3 years. You're in year 3 after rate case A and you haven't recovered. So you go into rate year 4 and you continue. And you're still not recovered fully at the end of rate year 4. You come in for rate case B in year 5, and you've still got this piece left. What was the historical practice of what you would do with that leftover piece that still wasn't fully amortized after year 4? What would you do with
We
it?
would have still booked the amortization that you approved in that rate case A. So if it was still going through, say, for example, you had awarded $20,000, we would have kept booking that $20,000 until it was fully recovered.
Okay, well, here's where I need to be sure I'm really tracking with you, is in rate case B, at the end of rate case B, we set new general rates, and those become the rates. So is the unamortized balance from rate case A folded into the base rate set in rate case B?
It is, because we would assume that we wouldn't adjust to remove that amortization because it's still ongoing.
You would have included that continuing amortization as part of your revenue requirement request
Correct. 'Cause
made in rate case B.
Because what happens now is amortizations are presumed to still continue until we remove them. So one of the adjustments you see in here is I have an adjustment that's called remove expiring amortizations. That's us taking out things that we think are ending. We're actually doing that for a lot of the over amortizations that you see. We're saying when new rates go into effect, that over amortization will stop. So we'll no longer have that.
Okay, stay with me here because I think I'm getting close to getting it. So in the prior practice, before we get to this case today, in the prior practice, you would have come in to rate case B, still carrying an amortized balance of rate case expense from A, and you would include that in your revenue requirement request for the rates that you want to be set in B.
Correct.
And that showed up in your revenue requirement, I'm sure, in your presentations.
Yes.
Did the public staff ever object to that?
Not to my knowledge.
In any past history that you're familiar with, in rate case B, did they say, no, that can't be included as part of the revenue requirement?
Not to my knowledge.
Thank you very much, Ms. Jig.
Commissioner Duffley and then Commissioner Kimmerite.
Also, a follow-up regarding Chair Mitchell's questions about the securitization. And so I heard you testify that the company and public staff disagree on the method of recovery and that public staff wants to defer and securitize. And remind me, DEP wants to...
We want to use the Hurricane Matthew over amortizations.
Okay.
To cover the cost of Winter Storm Izzy. The Hurricane Matthew over amortizations are about $17 million and would cover the amount that we want to defer for Winter Storm Izzy.
Okay, thank you for that. And so with the public staff's position of defer and securitize, would that deferral account or the asset be earning a return?
Yes, I believe we would.
Yeah. Are the markets ripe for, is it a good time to seek securitization in the markets right now?
That I cannot speak to.
Okay.
Again, I'm not aware of a set timing for when we would pursue that securitization, but we would, if their proposal is what you go with, we would record the regulatory asset and record a return until such time as we could get through all the steps to securitize. I believe it's a pretty lengthy process. So you're talking about, I think, at least 18 months to 2 years. It takes a while to
Okay.
get through all of that.
Thank you for that.
And Ms. Jacobs, one question following up from Chair Mitchell's question about the rate case expense and understanding that the public staff's position is that the entirety of the rate case expense should be disallowed. I think you testified to Chair Mitchell's question that you did not receive any feedback from the public staff that the rate case costs were unreasonable. So for clarification about that, did you receive any feedback at all from the public staff that the rate case costs were reasonable or that they were not objecting to the reasonableness of the costs? In other words, the reverse of that, did they affirmatively provide any information other than that they were disallowing the entirety of the rate case expense?
Just that they were disallowing the entirety. To my knowledge, we did not receive any feedback one way or the other with respect to those costs.
Thank you.
Just one question. Dealing with that securitization, each come up with threshold for the debt level that they would consider going at securitized, their amount of cost, then say some transaction. Because right now you said Ian was 53.
Ian is 53 on a system basis.
I would think that there would be a threshold that you want to be. You familiar with that or is that see?
Just a little bit, and I can tell you what I have learned. You're correct. There is a certain threshold that needs to be, I think we need to be at for this to be attractive for investors. And I believe the plan is that we would securitize costs for DEC and DEP together to kind of make it attractive.
That makes sense. The last securitization, I think about 83-42.
Yes.
That's called DEC. If we based in what funds is put into what the timing would be. And that's what leads you to ask that question.
Yes, we would, I believe, based on some discussions I've been in, like it would need to happen together. DEC securitizing their set of storms, which will be a little bit different, but we would do them at the same time.
Yes. Thank you.
All right, let me see if there are questions on commissioners' questions for this witness. Go ahead.
This is Ann Keyworth with Public Staff. In the last two rate cases that were settled by the company and the public staff, that would be sub 1219 and sub 1142, was the actual amount of, as of a certain date, what was agreed upon?
For 1219, we agreed upon $3.5 million as the revenue requirement for rate case expenses. For 1142, I don't believe there was a settlement. I don't think that the amount we proposed in that case was contested or discussed. So I believe what we proposed in that case is what went through, and that would have been our standard process was actuals as of a certain time and then a projection up through the hearing.
And did the company provide the expenses that the company continued to amortize to the commission or to the public staff for review for sub 1219?
Well, sub 1219, we're still only a few years into the amortization. We haven't gotten to the point where we need to extend it. Can you, if I'm understanding your question correctly, you're asking if we have done anything special to reflect recovery of 1219 costs. 1219 costs are still in the amortization agreed to in that settlement.
Okay, but have not been reviewed by the public staff.
Costs
for,
that,
sorry, for any rate case expenses that were projected.
I'm sorry, can you rephrase your question?
I'll move on. Does the public staff typically provide the company with advance notice or feedback regarding adjustments that it plans to make?
Not to my knowledge, not necessarily.
Okay, thank you. That's it.
Any additional questions? Yep. Mr. Meta?
No questions.
All right, with that, Ms. Jiggets, I believe you are finally done with your testimony in this case. Thank you for your participation and for being here with us, and you may step down and be excused.
Ms. Jiggets had no exhibits for her rebuttal, so nothing to move in. Thank you.
All right, you may call your next witnesses.
Thank you very much, Chair Mitchell. At this time, DEP calls to the witness stand Melissa Abernathy, Ms. Laura Bateman, Mr. Phil Stillman on rebuttal.
All right, good afternoon to all of you. Just a reminder that you remain under oath.
Good afternoon, Chair Mitchell, Mindy McGrath again with Troutman Pepper. Each of these witnesses has previously appeared, so I don't think we need to swear them in again. Good afternoon, Ms. Abernathy. Can you please state your name and your business address?
Melissa Abernathy, 526 South Church, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy Carolinas, Director of Rates and Regulatory Planning.
Ms. Abernathy, on April 14th, 2023, did you cause to be pre-filed in docket E-2 sub 1300 rebuttal testimony consisting of 19 pages?
Yes.
And do you have any corrections to your pre-filed rebuttal testimony?
I do not.
And if I were to ask you the same questions today under oath, would your answers be the same?
Yes, they would.
And Ms. Bateman, on April 14th, 2023, on behalf of the PBR policy panel, did you cause to be pre-filed in the same docket rebuttal testimony consisting of 60 pages?
Yes.
And maybe I'll take a step back and ask you to please state your name and business address for the record.
Yes, my name is Laura Bateman and my business address is 411 Fayetteville Street, Raleigh, North Carolina.
Thank you. And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas as Vice President of Carolinas Rates and Regulatory Strategy.
Thank you. And turning back to your pre-filed rebuttal testimony, do you have any corrections you need to make?
No.
And if I were to ask you the same questions today under oath, would your answers be the same?
Yes, they would.
Mr. Stillman, can you please state your name and business address for the record?
Yes, my name is Philip Stillman and the business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services and my title is Managing Director of Load Forecasting and Corporate Strategic Regulatory Initiatives.
And if I were to ask you the same questions that are in the PBR policy panel's rebuttal testimony under oath, would your answers be the same?
They would.
And do you have any corrections to your rebuttal testimony?
No.
Ms. Abernathy, did you prepare and cause to be pre-filed on May 3rd, 2023 in this docket a summary of your pre-filed rebuttal testimony?
Yes, I did.
And Ms. Bateman, on behalf of the PBR policy panel, did you cause to be pre-filed on May 3rd, 2023, a summary of the panel's pre-filed rebuttal testimony?
Yes, I did.
Chair Mitchell, at this time, I would like to request that the pre-filed rebuttal testimony of Ms. Abernathy, the pre-filed rebuttal testimony of the PBR policy panel, witness Abernathy's rebuttal testimony summary, and the summary of the PBR policy panel's rebuttal testimony be entered into the record as if given orally from the stand.
All right, the rebuttal testimony filed on behalf of DEP witness Abernathy on April 14th, 2023, consisting of 19 pages, will be copied into the record as if given orally from the stand. The rebuttal testimony filed in this docket on April 14th, 2023 for DEP witnesses Bateman and Stillman, consisting of 60 pages, will be copied into the record as if given orally from the stand. The summaries to those testimonies will also be copied into the record as if given orally from the stand.
Thank you, Chair Mitchell. The witnesses are available for questions.
All right.
And cross.
No questions.
Okay. Sigfer.
Good afternoon, Ms. Bateman. These questions are going to be for you. Do you recall the map that you made and then submitted as a late filed exhibit regarding what modernized regulatory mechanisms are present in other states in the United States?
Yes.
Do you have a copy of that map with you?
Yes.
If you could turn to that, please.
Okay.
So, Ms. Bateman, you indicate here that the brown colored states are those states with 2 or more mechanisms. Is that correct?
Correct. And I listed out the mechanisms that I included or that I was looking at when considering that.
Did you consider which states have 3 or more mechanisms?
I did not look at that.
Do you know off the top of your head which states have 3 or more mechanisms?
So I did, I believe with the late filed exhibit, there was a kind of a table of each state in which mechanisms that state had. And so I think somebody could look at that table and check off which states had 3 or more.
So am I to understand you correctly that somebody can make their own map perhaps and shade in the states that have 3 or more mechanisms based on the other piece of the late filed exhibit that you?
They could. I will note North Carolina has 2. And so I think, you know, kind of in looking at this, I was looking at North Carolina compared to other states. And so they either were equivalent to North Carolina or had more than North Carolina.
Thank you. That takes care of it.
Okay. CUCA.
Thank you, Chair Mitchell. Ms. Bateman, my questions will be directed to you. Do you recall on page 11 of your testimony that you addressed Mr. O'Donnell's request for a 10-year rate forecast?
Yes, just give me a minute to get there. Okay.
Right, and so you're aware that Mr. O'Donnell represents industrial customers?
Yes.
Right, and he's making that request on behalf of industrial customers?
Yes.
Right, and just to confirm that despite his request on behalf of the members of CUCA, Duke's refusing to produce or provide a 10-year rate forecast?
I want to add some context to that. We don't have an all-in 10-year rate forecast. And so it's not like I'm holding on to something and refusing to produce it. We don't have it. We have not created it. I think there are some dangers to creating and publishing something like that you know is going to be wrong, because there are things that are just volatile, some of which are outside of our control. And so I think, and then also in listening to some of the industrial customers, kind of what their desire was for the forecast, it was to compare states, compare service territories, where they might locate, where they might ramp up production and ramp down production. And so one, I wasn't aware, I couldn't find any other state, any other utility that provided such a forecast. But even if they did, an industrial customer, you would really want to look at forecasts using the same inputs, the same assumptions. And so it's probably even better to have some third party, you know, using the same assumptions, do their own forecast based on our publicly available information. You know, just they could do as well as we would with the things that are uncertain, fuel costs, interest rates, things like that. But make the same assumptions across different service territories if you really want to get a good idea of where you would want to locate or what electricity costs might be in the future.
Right, so in response to the request, Duke is saying that industrial customers can create their own forecasts. Duke will not provide one.
I think it would be dangerous for Duke to provide it. I'm not aware of any other utility that does. And I do think it would be a better way for them to evaluate different states if they did it on a similar basis rather than have different utilities in different states preparing the forecast for them using different assumptions.
Turning to page 49 of your testimony, do you recall that you address CUCA's proposed concept of a fuel cost PIM?
I'm going to refer that to Mr. Stillman.
Oh, all right, Mr. Stillman. Sorry, I apologize. I assumed you knew at all. You answered so many of my questions.
Could you
Stillman,
remind
no
me,
offense.
which page was that?
Page 49 of the testimony.
Yes.
All right. So, Mr. Stillman, am I correct that you believe a fuel cost PIM is not appropriate?
I agree that it is not appropriate.
Starting on line 12 of page 50 of the testimony, you identify several, quote, creative and proactive, unquote, measures that Duke has implemented to reduce fuel cost volatility. Do you recall that testimony?
I do.
The first example is that DEP has a robust natural gas financial hedging program, which has been in place since 2006. Is that right?
Yes, and I should say that in gathering these mechanisms that we've used to try to contain fuel costs over the years, we've talked to the fuel optimization group about that. So those are the subject matter experts that we turn to understand what are the mitigants that they put in place to help contain fuel costs.
Well, is it Duke's position though that that hedging program is effective in mitigating price volatility?
I believe that, yes.
Another mechanism you mentioned is on line 19 of page 50, which is the JDA. Does Duke or does the JDA allow Duke to mitigate price volatility?
I believe so, yes.
And then two other examples you mentioned of mitigating price volatility are on page 51, line 1, and then line 10. I'll just mention them for you. You mentioned, I believe, what you call creative contracting facilities and energy trading. Would you mind elaborating on what those mechanisms are?
So are you speaking of the one face to the market?
Yes.
Okay, so this is essentially what I know from talking to our subject matter experts is what is in my testimony here. But it's this fuel procurement strategy that they've worked on to try to, again, contain the costs.
Right, and it's Duke's position that that fuel procurement strategy is an effective means of mitigating price volatility.
I think all of these items that we've been talking about are ways to help the company contain fuel costs, yes.
Going back to page 50 of your testimony, lines 4 and 5, in opposing the fuel cost PIM proposed by CUCA, you testify that you, quote, disagree that the annual fuel proceedings lack effective prudency review. Do you recall that testimony?
I do.
Right. At page 52 of your testimony, you point to 3 fuel rider proceedings in which the commission disallowed fuel cost. Am I right?
Yes.
All right. Now, all 3 of those dockets that you cited in your testimony involve the public staff recommending a disallowance of, quote, power replacement costs, end quote, because of an outage at a nuclear power plant. Am I paraphrasing those orders correctly?
I'd have to go back and look at the orders to remember exactly what was disallowed. But I do agree with what you said, and there's been a lot of conversation over the course of the last week or 2 weeks about the completeness of the audits that happen. And we're talking about the completeness of the audits that happen within the fuel clause. And that's why I believe that this is not really a proper PIM, because this can be all looked at and all audited through the fuel clause process, and costs could be disallowed if they're found to be imprudent.
Right, but in the 3 dockets you cite in your testimony, in none of those dockets was there a disallowance based on the company's management of price volatility of fossil fuel, correct?
Again, I'd have to go back and look at what the particular disallowance was.
Going back to page 50 of your testimony, line 3 and 4, a final reason, I'm sorry, don't mean to go too fast.
Page 50?
Yes, sir. A final reason that you disagree with the concept of a fuel cost PIM is you don't accept the allegation that DEP has, quote, no incentive to manage fuel costs. Am I correct?
That is another, I won't call it the final,
Okay.
that is another reason, and we just went through three or four pages in my testimony of all of the activities that the company partakes in order to contain those fuel costs. And I'll also, I've gone to the NERP document a few times, and in the principles for establishing a PIM, partway down under those principles it says that no adopted PIM should duplicate a reward or penalty created by another PIM or other legal regulatory mechanism. So I believe that this is the PIM as proposed in terms of the fuel costs, containing the fuel costs, is really all contained under that regulatory mechanism in fuel proceedings.
Now, but to be clear, if fuel costs go up $100 million over the course of the year, Duke passes that entire expense on to ratepayers, correct?
Did you?
Well, I think it's yes, but it's without any, at least as far as back as I can remember, we have not requested any financing costs. So I do think there is a sharing of the pain if there is under recovery.
Sure, and the under recovery would be with Duke not accurately forecasting the costs, correct?
Not necessarily. It could be, I mean, you make it sound like we should have a crystal ball and know exactly, like anyone can accurately forecast fuel costs, a year, 2 years out. That's just simply not the case. And so we make a projection of fuel costs, but then there's also volume too.
Sorry, my point was that under recovery is because of inability to predict fuel costs. It's not necessarily because the fuel costs increase or decrease, correct?
It could be any of those.
Well, if fuel costs increase and Duke were to accurately predict the fuel costs, there would be no under recovery, correct?
That is correct.
That's my point.
Okay.
So, Mr. Stillman or Ms. Bateman, so there is no direct correlation between a change in fuel costs and Duke's financial profits, correct?
I think, again, you're getting to the point that the cost, as Ms. Bateman mentioned, are a pass-through for all intents and purposes. But to the extent that there is imprudency or something that is identified where the company was well, again, I'm going to use the word imprudent again, and those costs get disallowed, like the examples that we gave, then I would disagree with the statement that you just made.
At page 53 of your testimony, you recognize that other states have mechanisms to allocate fuel cost risk, correct?
Yes. Fine.
All right. CUCA's proposal is a 90-10 split of risk. Do you recall that?
Yes.
Okay. Are you aware that other states such as Wyoming and Utah have a 70-30 split where the utility bears up to 30% of the risk of fuel cost changes?
So I'm aware that that was in your testimony. We went and looked at that. I think Hawaii is not maybe a good peer company to compare to. There's a lot of extenuating circumstances there. One is essentially the fuel cost is a component of their bill. First, their bill is the highest bill in the country, I believe, if it still is. And the fuel component is much larger due to having to bring in the petroleum and things like that. So Hawaii is really not a good example. And I did go and look at the other states, and again, the sharing mechanism that you just talked about is all embedded in the fuel clause as best as I can tell.
In creating a fuel cost PIM, if it were the commission's desire to do so, the commission could cap the fuel costs at a certain dollar amount, could it not? In terms of Duke's financial exposure to a change in price.
I'm sure they could. I think the difficulty here would be to try to determine what the metric is that you're going to measure yourself against. Is it a forecast? I think in the testimony that KUCA had, that CUCA had, excuse me, you threw out a couple of examples to say it could be a forecast, it could be the previous years, it could be a mixture of. I think this gets into the difficulty of trying to set an appropriate metric in which you can measure yourself against.
And I would just add to, you don't want to have unintended consequences from your PIMs. And if you create all this risk on the utility, obviously you incent the utility to lower its fuel costs. One way to do that is by adding resources that are zero fuel cost resources. And we are doing that. We are doing a lot of that in our projected plans. But at the same time, you want that decision to be made kind of holistically in terms of what's in the best interest for customers. You don't want it to be swayed one way or another based on a PIM that only looks at one piece of the equation.
And if I could add to that, again, I'd go back to the NERC document, and the one piece of the equation made me think there's another principle in that document in setting PIMs, saying that you should not set it on levels of expense, for example. That's not a good metric to measure a PIM against.
Sure. Well, and if the commission wanted to limit how much weight Duke gave a certain PIM, they could cap a fuel cost PIM, for instance, at $10 million. So therefore, Duke would never lose or gain, because it works both way, more than $10 million a year, correct?
I think that's the idea of the PIM is what you just pointed out.
And this past year, there was a roughly $1 billion under collection for fuel costs. Am I right about that, roughly?
That was for DEC.
Okay.
So different utility, but yes, you are correct on the DEC number.
The DC. Okay. So just using that number as an example, if a fuel cost PIM were capped at $10 million, then a $1 billion increase in fuel costs would mean that ratepayers would pay $990 million and Duke would only pay $10 million, correct?
So just a couple of things on that. I think you established that whether or not we have an under collection is really just a difference in the forecast versus reality versus actuals. And I think you were saying that you wouldn't create a PIM that just measured our ability to forecast versus where actuals came in. So I don't think that would be accurate. And then also I'll just point back to the financing piece. So on that $1 billion, if you think about the average of the test year for DEC fuel it's a 2021 test year. So the average of that test year versus the average of when you'll collect those costs, it's almost 2 years, slightly under 2 years, 1.5 years to 2 years. And the company is financing that $1 billion. And if you look at current commercial paper rates or interest rates, whatever you might assess that we're financing that at, it's close to 5%. I mean, DEP just issued some debt at 5%. And so that's like $100 million that the company is not asking to recover of that amount. And so I think that's just an example of how we are kind of more than sharing right now. And I know that deferred balance it's a big issue for the company. It's a big issue for customers. But so I just wanted to point out that kind of what I referred to with financing costs is significant.
Sure, but I was just trying to confirm Duke's potential risk exposure under a fuel cost PIM. If costs did increase over $1 billion and there's a $10 million cap, ratepayers would bear $990 million of the price change and Duke would only bear $10 million, correct?
I'm not sure I agree with the characterization of only $10 million. $10 million is a meaningful number.
Okay, right. So it's 990 million, isn't it?
Yes.
Right. No further questions.
Menashe Megura on behalf of NCJC et al. NCJC et al. Has no questions for Cross.
No questions about that.
No redirect. Okay. Questions from commissioners? No questions? Any questions? All right, a few from me. Let's see, the, EV sales. We're a little bit unclear on the status of the exclusion of EV sales from the decoupling mechanism. Because as we read the stipulation, the parties have agreed to do, have agreed to 2 steps. Develop and file tariffs or programs to estimate and update the revenue associated with residential EV sales within 90 days of the commission's order in the docket, and then update the estimate of the 180 kWh proposed by witness Nader with actual DEP-specific EV usage data in each future decoupling rider. So we're trying to understand sort of exactly what have you agreed to for purposes of this proceeding? What level of sales are to be excluded?
Yes, so we would start with what the company has proposed. So using the DMV data, using some analysis to get that down to DEP residential. And then we would use the 180 kWh per vehicle, and then the flat rate residential tariff. So that's how we would calculate it to begin with. And then we would file those the tariffs or programs as we agreed to under the settlement. And then we would use the data from those tariffs and programs to refine the analytics to update those numbers that we're using initially.
Okay, and when would the update occur?
That I would think you would need enough history with those programs and riders that are filed to have good analytics. So, I don't know, but I would think it wouldn't be before that first decoupling rider.
Okay. Okay, so you do envision an update in the rider and not necessarily until all the way until the next rate case. Okay. Are you all proposing that the method of estimating EV sales for the decoupling mechanism be the same for the ESM?
Yes.
Okay, so you'd be consistent. Okay.
Yes.
All right, Ms. Abernathy, your rebuttal testimony agrees to amend the EV adjustment for the ESM based on DOD witness Blank's testimony. Is that still the company's position?
Yes, we will adjust that so that we're essentially adjusting out the net revenues there.
Okay, and you'll be consistent with that adjustment across for both the ESM and decoupling?
Yes, I think it'll be the exact same adjustment.
Okay. This adjustment wasn't referenced in the stipulation, so we wanted to make sure we were clear on whether you all were still agreeing to it and how it would be applied. All right, Ms. Abernathy, at the top of page 5 of your rebuttal testimony, let me know when you get there.
I'm there.
Okay. You talk about the difference between rate effective period and the deferral period for the decoupling rider. You state that the rate effective period is after the multi-year rate period. So we assume what you're saying is that the decoupling rider would last for a period after rate year 3, but only to the extent necessary to collect or return any amount calculated from the rate year 3 decoupling calculation. Is our understanding correct?
Yes, that's correct.
Okay.
You have to get to the end of rate year 1 to calculate the total amount to go into the decoupling rider.
Okay.
And then that would go through the levels of review and be returned or collected over a 1-year period. So each kind of tranche of it would follow after the technical end of the rate year
So
plan.
it
until
lags
that.
the rate year, and I got you. Okay.
But the calculation itself of deferral amounts to put in a rider would end at the end of rate year 3.
Okay. Okay, let me see if there are questions on commissioners' questions for this panel. All right, I'm not hearing any, so let me just make sure I don't have any other notes coming in. All right. With that, we've come to the end of your testimony. You all may step down and be excused. Thank you very much for your participation in this proceeding and for your testimony. Mr. Mehta, I do not believe these witnesses had any exhibits, or I'm sorry, Mr. Pratt. Okay. All right. So we have come to the conclusion of this hearing. For now, I would like to ask council, are there any procedural matters for my attention before we wrap it up?
None from DEP at this time.
Okay.
Chair Mitchell, I would just note that SIGFR 2 has an outstanding motion to reserve its right to
All right.
cross.
I'm going to get to that. But,
Nothing from the public staff at this time.
all right. All right, we're going to hold the record open for the purpose of receiving late filed exhibits that have been requested by the commissioners and any supplemental testimony of the public staff on the third update provided by the company back on April 18th. The commission will later determine if there's a need to reopen this hearing or reconvene this hearing to receive further testimony or cross-examination on those later filed items. All right, transcripts, not including all of the exhibits, is expected to be ready by this Friday, which is May 19th. And I would call for proposed orders by Friday, June 9th. If there is an additional hearing held, if we reconvene the hearing for the purpose of taking additional testimony, we will provide you all with some additional time to update your proposed orders or provide supplemental proposed orders on the items or matters addressed in the continuation of the hearing. The date for proposed orders will not be extended due to additional supplemental testimony or late filed exhibits. All right, any questions on the foregoing?
Just one question. If the hearing does have to be reopened, does the commission have a date and
We do
time
not.
in mind?
We do
Okay.
not. I will do my best to find one and provide notice to the parties at that time. It will be before August 21st. All right. With that, I would like to take a moment, if I may, to express my appreciation to the parties for their efforts in this case. You all have had an incredible workload. I'm looking at my colleagues in the back of the room in particular. Over the past several years, as we hear in this case about things like rulemakings and securitizations and planning proceedings and other matters, it's been an incredibly busy couple of years. And I appreciate that you all are putting forth the effort and being civil to one another and helping us develop records that are robust and thorough and certainly voluminous so that we can be in a position to make decisions that are in the public interest. So with that, again, I would just like to say thank you to all of you. And we will be off the record. Thank you very much.